My lord, my witness is in the box. I'm for the plaintiff. I've given notice to my learned friend on the other side who is also represented. My lord, my witness is not available. So I have spoken to my learned friend who is there on the other side, and she's agreeable to these dates barring 20th and 21st of May. When she is in difficulty, she has indicated. I've given dates till July, as in when the witness is available.
जुलाई में क्या डेट है खाली
June, if it's possible for your lordship.
June, I don't think any date is available for witness action. तो पहले कुछ नहीं है जून में.
But I'll just indicate, my witness was in the box. I was doing the examination in chief. It was almost complete when the other side took the point that there are certain documents which were not disclosed earlier in the plaint and which I have disclosed for the first time, although I had given inspection to them. So at that juncture, the witness action was stalled, and I have to only put him few questions. At least if half an hour's time is given to me on any day in the month of June also, then I will be able to at least complete the chief. Then my learned friend can do the cross-examination.
What time? लेकिन उनका 17 June your witness will not be available. 19, 20, 21, 22 कुछ भी नहीं है. 24 कोई भी नहीं. 11:30
Half an hour, for half an hour if it's
11:30
given.
है कब है 23rd 11:30 record and who is for the other side
My learned friend is there.
record and order.
Item number 22.
Item number 22. Though the matter is listed today as item number 22 under the heading witness action, counsel for the plaintiff submit that due to some personal difficulties, the witness of the plaintiff is not present and paid for fixing another date. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 23rd. But 23rd is also not. 19 to 22. 20, 22 तारीख 19, 20, 21.
3 seconds. आधा घंटा दाव ताली. Half an hour.
21, 22 ऑलरेडी. 19 भी फुल है. 25, 24, 25 नहीं है. 25th June.
Grateful to lordship.
25th June at 11:30 for witness action. Yes. Leave granted for dispensation of requirement under section 12A of the Commercial Code at date is revoked. Suit is dismissed.
My lord, is it your lordship pleasure to, my lord, grant me the period, my lord, of exclusion? My lord, because, my lord, when I refile after coming back.
You
But-
file it. I cannot grant at this stage. You go and file it. It is because you will find that.
Very well, very well. Lordship.
1, 2, 3, 1 and 2. As regard the limitation, I have dismissed. As regard the amendment, also I dismissed. Both application dismissed. Should remain, but I have not allowed the amendment.
My lord, would your lordship consider fixing a date, my lord, for the hearing of the injunction application?
Which one?
My lord, GA1. Because affidavits are complete.
Ah.
It's my injunction application, my lord.
Okay, means after vacation, I will.
Very well. As my lord pleases. Grateful.
After reopening, you mention.
Grateful, my lord.
Number 6. I appear to plaintiff, my lord. I'm praying.
This is my presentation of plaint.
Yes,
The suit is after the non-starter report has been given.
after non-starter
Yes,
report.
it is at page 88, the
Yes.
last annexure.
25th June
Yes.
24.
24. Now, the plaintiffs are within, the sole defendant is outside. The work order, 10 numbers of work order, those were issued. Those are within. And my lord will find at page 6. The checks which were dishonored, were presented, both the banks are drawn on and the present bank are within. My lord will find at page 6, page 8,
South India Bank Limited.
Church Lane, and HDFC Bank, Bada Bazaar branch. We have a 138 proceeding pending before Bankshal Court. Those are all there. I am seeking for
This transaction, the
Yes.
dishonor has happened
within.
What was the last date of the dishonor?
The last date, my lord will find at
July
page
2022.
2022 December. At page 20, paragraph 24, page 12.
Paragraph 24.
December 22, 2022.
I see.
Then admission, at page 13, para 25, that is on
16 March.
in March.
April 2022.
Yes. Will find page 12, paragraph 24.
Yes.
Kindly see
What did we paid for?
order to rule 2 and clause 12.
Why order to rule 2?
Subsequent events to include to on a
The
safer side.
recovery of money. What the order to rule 2? Sir?
If damages, you have to seek amendment and all those things. To be on a safer side, my lord, somebody starts the suit, conclude somebody else. So, not to.
So and so suffering for the plaintiff. Plaintiff has filed the present suit, praying for decree for a sum of rupees 30 lakhs, along with the interest at the rate of 12% per annum. Full stop. Plaintiff submitted. The plaintiff has already initiated the pre-institution mediation process, and non-starter report has been issued. Full stop. It is submitted that the plaintiff is within the jurisdiction of this court, and defendant is outside the jurisdiction of this court, but the check issued by the defendant were dishonored within the jurisdiction of this court, and as such part cause of action arose within the
Work orders received within jurisdiction.
check issued check issued was dishonored within jurisdiction of this court, as well as the work order was also issued within the jurisdiction of this court. Full stop. It is counsel for the plaintiff submitted that there is chance that further damage can be claimed by the plaintiff, and as such he also paid for leave under order to rule 2 of the CPC, as well as leave under clause 12 of the latest patent. Consider the submission made by the counsel for the plaintiff, peruse the materials on record and the pleading. It is leave under clause 12 of the latest patent, as well as under order to rule 2 of the CPC is granted. Plaintiff is admitted subject to scrutiny.
Obliged. Scrutiny has been done for more than a month. I took leave day before yesterday at the evening.
Yes.
Well, this is my application for setting aside an award.
Hello, this was fixed at 3 p.m. Your Lordship may record that by consent, Your Lordship is taking it.
Yes, yes.
Ready?
No, I'm ready. Yes. It was ready for 3 p.m.
Yes.
My lord, before I take my lord to the award, my lord has dealt with the Section 9 application in this connected matter, my lord. So my lord the facts would come back to my lord. But there was a company called my lord Adhanik, which had a mining lease, my lord, from the state of Bihar in the year 1976. This lease, my lord, was extended in the year 1996 thereafter, after 20 years. The initial lease was of 20 years. This lease was extended by the government of Bihar, and the petitioner here, my lord, was given a license to mine iron ore at a mine called Ghatkuri in district Singhbhu. This was for another period of 10 years. Now in 2005, thereafter, there were two agreements, executed with the leaseholder, that's my client, and the respondent here, which is called Synergy. On the same day, there was another agreement executed between the mine holder, which is my client, and a sister concern of the respondent called Metsil Exports.
Maxil.
Metsil, METSIL. Now, Metsil had entered into an agreement for raising the mines. So that agreement was titled as a raising agreement. Synergy, this is a separate agreement executed on the same day. It was called selling agreement. I shall take through the terms of the agreement, but briefly just telling the background. The selling agreement had visualized that there is a separate contractor, which is Metsil, who shall raise the mine, the iron ore from the mines, and the entirety of the iron ore which is raised shall be sold to the respondent here, which is Synergy. So whatever is excavated will straightaway be sold. So both the agreements were executed on the same day. This agreement was for a period of 7 years. The one which is the subject matter of the present proceeding. Now this was executed on 27th February 2005. The starting point of this 2005 agreement was the effective date was from the date it comes to the force or when the commencement of the mining operations shall be allowed by the government. That was the date with the starting point of the agreement. Now, this was 2005. It is the petitioner's case, that in 2007, the petitioner herein had terminated the contract on various grounds, including the fact that this agreement itself is void because it contravenes regulation called yes, Rule 37 of the Mineral Concession. So it was the idea was that my client terminated the contract in 2007, saying that this in itself, the scheme of both these agreement is to give the entire mining operations to someone else who is not licensed with the mine. So this contravenes Rule 37 and therefore is void, ab initio. This was the ground taken inter alia, some other grounds that they were breach. It was terminated in 2007. That's my case. Now, then series of negotiations took place. Ultimately, in 2010. Now, between 2000, after the execution of the agreement and 2006, they paid a sum of rupees 1,67 lakh odd to the petitioner. And then it was terminated. It's our case that we had offered to refund the money also, which was not accepted. Now, on 24th December 2009, it was for the first time that the respondent here in alleged that I am in breach of this agreement. This letter was immediately replied on 11th January 2010, and it was stated that we have terminated this contract way back in 2007. And in any event, this is void. So there's no question of any breach of that agreement. Now, there were letters exchanged. Immediately after my reply, we had also enclosed this letter by which it was terminated. The letter, the postal receipt, and everything, the documents were disclosed. That's the case made out in the statement of defense. Now, they responded by saying that, sorry, this letter was never received by us in 2007. And in fact, this letter is forged and fabricated document. Now, in response to this letter of 3rd February, the petitioner replies and says, we have sufficient documents to show it was dispatched, the postal receipt and the acknowledgement card, and this was disclosed. Then, my lord, this led to dispute. And on 22nd August 2010, a Section 21 notice was issued. This was replied by my client on 21st September. And then, my lord, immediately a Section 9 application was moved. I shall take my lord through this. And then the my lord, statement by the High Court, an arbitrator was appointed. And my lord, then the proceedings commenced before the learned sole arbitrator. My lord, this is the background in which, my lord, this reference, my lord, started. My lord. I shall first take, my lord, straight away to the award, because unless I show the award, my lord.
What is the ground?
Yes, the ground for setting aside.
Ground
Yes.
for setting.
So, my lord, so the statement of claim really was, my lord, for specific performance of this contract. In the alternative, damages in lieu of specific performance if it is not. That was the prayer made. The learned sole arbitrator has ordered specific performance. Now, my lord, the first and foremost ground, which before I take my lord through the award, the foremost ground of challenge, this is against public policy. And why I say this? Because, my lord, the petitioner, if my lord compares the name of the petitioner is Odisha Manganese and Minerals Limited. And if my lord sees the agreement, my lord, the agreement, my lord, is with another company called Adhunik. Now, my lord, we have come into the picture. This Adhunik went into a corporate insolvency resolution process under the Insolvency and Bankruptcy Code in 2018. But the CIRP, my lord, began on 3rd August 2017 when, my lord, the resolution professional was appointed. And, my lord, several plans were invited. My client had also participated in the process and submitted its resolution plan. And on 22nd June 2018, my resolution plan was approved by the Committee of Creditors. And upon approval of the resolution plans, my lord knows that all pre-existing dues, claims, all stand extinguished. So therefore, it's my case, my lord, that the fact that the clean slate theory, my lord, applies, means that I cannot be burdened with any past liabilities or obligations of the corporate debtor, as it is called in the Insolvency and Bankruptcy Code.
Have you taken the same ground before the arbitrator?
Yes, I shall show this ground was taken and rejected. My lord knows the objective, my lord, of this Insolvency and Bankruptcy Code permitting plans to be invited, my lord, is to encourage resolution applicants to invest into a company which is in doldrums and keep it shielded of any uncrystallized debt or hidden liabilities or unknown liabilities or liabilities which have not crystallized into a debt, so that Hydra head subsequently popping out should be, my lord, avoided. The entire purpose of this act is this, that, my lord, a resolution applicant who takes over a company will only pay, and his obligation is only to pay off the creditors who submit their claims before the resolution professional in course of the CIRP. And those claims are admitted or rejected by the resolution professional. And claims which are admitted are then placed before the COC. And the plans provide for payment of those admitted debts. And once, as a resolution applicant, my lord, I pay whatever is due, whatever I had committed under the resolution plan, I can then start the company on a clean slate. And whatever the company had done prior to its CIRP date, it is immaterial. In fact, in the case at hand also, my lord, this respondent had submitted its claim before the resolution professional.
This claim.
And, my lord, ultimately,
what has done that?
The resolution professional did not, because it was an uncrystallized debt at that point of time. So it was rejected. It's my contention, my lord, that under the resolution, under the Insolvency and Bankruptcy Code, there are only two classes of creditors. One is operational creditor, and the other is financial creditor. Once, my lord, these creditors are paid under the resolution plan, I thereafter, my lord, cannot be made liable to any further obligations of the corporate debtor. So therefore, my lord, this is my first argument, and my lord, in my respectful submission, I'll persuade my lord to accept this argument that, my lord, once the resolution plan is approved, my lord, I cannot be burdened with any past liabilities of the corporated. I have come into the picture in 2018 December when my plan got approved, and I am entitled to take this company ahead with a clean slate. That's my first argument, and this argument has been rejected by the arbitrator, and therefore I had no other recourse. I had to participate in the arbitration proceeding. I did participate, and then, I have, in my section 34 application, have taken this point.
Okay.
This is the first point that I had taken. The second point, on which I would attack this award is that, this arbitration agreement itself is void because of Rule 37 of the mining concession rules. Second, the sale agreement itself is also void because of the same reason. So the arbitration agreement is void. The agreement is void. That's the point. Third, fact that Metsil, the raising contractor, and Synergy, both were under common management, and this was hidden from the petitioner at that point of time. That's the case that has been run. The scheme of the agreement was to give the entire control to a third party, and therefore it was violative of the law, and therefore it's against the public policy. And this argument has been rejected by the learned arbitrator. Of course, the next point is of bar of limitation, which the arbitrator should have considered. That's my third argument, that the contract was terminated by a letter of 2007. There are postal receipts, there are AD card. The letter is written to the post office. They have confirmed this letter was delivered. The reference was initiated long after 3 years. This argument has also been rejected, and the arbitrator has held the document appears to be a manufactured document. I shall take through the findings of the arbitrator on that also.
Evidence was fled or oral?
Yes, evidence well. All these documents were placed on record. Now, the next fifth argument is the bar under the Specific Relief Act and the Contract Act. I would say, my endeavor would be to argue, that in this kind of contract, which is it's inherently determinable in nature, damages should have been the only recourse. In fact, the claimant had also claimed for damages only. The arbitrator has proceeded to direct specific performance. And my first argument was that damages was adequate relief, also asked for as an alternative relief, but specific performance was granted. Third, I say the contract runs in several details, which any court or tribunal cannot oversee the performance. Knows a contract which
whether it is alternative argument.
Yes,
specific is not, but they can damages can be granted.
That was the alternative argument. The first prayer was specific performance.
No, you are.
My case is this is not a contract which could have been specifically performed for two reasons. One, that by nature it was determinable in nature, and secondly, the contract had such several details which any court cannot oversee specific performance. Because the continuous duty of court to oversee performance is impossible. So this reason also, because the arbitrator today says that I have to sell these, whatever I excavate, I have to sell it to them. Who will oversee this? To avoid this difficulty, the law says that where a continuous duty of overseeing the performance is involved, the court will refuse performance. The court will, in the alternative, direct damages. That's my next argument.
Okay.
And of course, the last argument is of Ghanshyam Mishra, the celebrated judgment. In fact, ironically, Ghanshyam Mishra is the applicant in this case. Resolution applicant, Ghanshyam Mishra, is the applicant in this case also. So the same matter which has gone to Supreme Court, and the Supreme Court is with some other creditors has held that all pre-existing dues get extinguished. The same Ghanshyam Mishra, there were 5 applicants, consortium of applicants. Ghanshyam Mishra is one of them. Ghanshyam Mishra had gone up to the Supreme Court, and it is in my case that it has been decided that this 2019 amendment is retrospective in effect.
Given effect.
And which will have a clean slate theory. So this is the broad background of my challenge, my lord.
Okay.
May I take, my lord, through the award once? Page 48, volume 1, my lord, is the award. And I shall, my lord, first, my lord, kindly straight away takes page number 52. First 6 paragraphs are the prelude, and this is necessary, my lord. May I place paragraph 1 onwards, my lord?
Yes. Page 52.
Page 52, the award starts, my lord.
Yes.
This reference has a very long checkered history. The disputes between the parties were referred to me by the division bench presided over by Justice Kalyan Jyoti Sengupta by order dated 17th April 2012. Pursuant to my directions, pleadings were filed. Both the parties adduced oral evidence, disclosed large number of documents in support of their case, and commenced their argument. When Leonard Senior Counsel for the claimant brought my attention to the National Company Law Tribunal as an adjudicating authority under the IBC had passed an order of 3rd August 2017, wherefrom it would appear that an insolvency petition at the instance of a financial creditor has been admitted and moratorium had been declared. He pointed out that Section 14(1)(a) of IBC specifically covers the arbitration proceedings, and therefore continuation of the present proceeding was specifically prohibited. Therefore, no further hearing would take place till such time the insolvency proceeding was resolved. In the sitting number 30, held on 30th September 2018, counsel for the respondent submitted that by virtue of the resolution plan, my mandate as arbitrator has come to an end. The resolution plan was approved on 22nd June 2018. Thereafter, disputes arose whether my mandate has come to an end or not, and it was contended by the respondent, which is my claimant, that after the resolution plan is approved, no further claim can be entertained. On the other hand, counsel for the claimant opposed the submissions made on behalf of the respondent, and his submission was that claimant's case was for specific performance of the contract. The reference could proceed and there was no hindrance to such proceeding. The respondent in rebuttal submitted all claims and legal proceedings stood extinguished and relied upon the affidavit of Vikas Jha filed before the NCLT. The counsel for the claimant gave his reply to the submission made on behalf of the respondent. I accepted the submission of the claimant's counsel and held that the reference could proceed. Thereafter, when the argument was about to commence on 113th sitting held on 13th March 2020, counsel on behalf of the respondent submitted that in view of the order passed by the Honorable Apex Court in Committee of Creditors versus SR Steel versus Satish Kumar, the arbitrator ought not to proceed with the proceeding, and the said judgment conclusively decided the issues raised and disposed by the arbitrator's order of 18 January 2020. The respondent filed a review of my order to stay all proceeding. A formal application was also filed by the respondent. After prolonged hearing, I rejected the review petition filed by the respondent for reviewing the order of 18 January and directed the parties to proceed with the reference. Thereafter, the counsel of the parties commenced their argument, but because of pandemic, hearing was kept in abeyance. The counsel thereafter commenced their respective arguments. Now, my lord, we'll see paragraphs 6 onwards, my lord. We'll find the facts of the case stated from 6 to, my lord. I shall not take, my lord, through the entire award immediately, my lord. 6 to 17 is the claimant's case, my lord. May I just place this part of the award so that my lord gets the grasp of the facts, my lord, that was before the arbitrator. The dispute between the parties, paragraph 6, arose out of an agreement dated 27 February 2005. It has been averred by the claimant that in or about February 2005, the respondent represented that the respondent was authorized to carry on mining at Ghatkuri district, Singhbhum, in the state of Jharkhand by virtue of an agreement of 20th February 96 between the respondent and government of Bihar. The respondent further represented it was holding a valid lease in favor of which was in its favor, which was not in operation for want of requisite permission by the Ministry of Environment and Forest. On basis of the aforesaid representation, the parties entered into an agreement dated 27 February 2005, hereinafter referred to the sale agreement, on terms and conditions embodied therein. The said agreement contains in the following terms. The said agreement would be valid for 7 years, effective from the date of coming into force or commencement of mining operation. the respondent during the currency of the agreement would exclusively sell to the claimant the entire iron ore excavated by raising contractor, and the claimant would purchase the entire ore excavated by the raising contractor. The claimant would have exclusive right to deal with the ore purchased from the respondent as they deem fit and to sell the same in domestic and international market. In consideration that the claimant would pay to the respondent the price of iron ore at the rate and manner provided in Annexure A to the attached agreement, and the respondent would raise invoices duly supported by payment slip. Claimant was to pay a sum of rupees 250 lakhs as adjustable advance in terms of the clause 5 of the agreement. The respondent acknowledged that the iron ore agreed to be sold exclusively to the claimant is not an ordinary article of commerce, but is of special value and interest to the claimant and not easily obtainable and available in market. The respondent acknowledged that compensation in terms of money would not afford adequate relief to the plaintiff in the event respondent fails to supply the claimant exclusively the entire iron ore raised by the raising contractor. In the event the respondent fails and neglects to supply exclusively to the claimant the entire iron ore in terms of the agreement, the claimant would be entitled to claim specific performance of the contract, and the respondent acknowledged such fact of the claimant to the claim specific performance. Para 9. The respondent at all material times represented to the claimant that the mining operations was yet to commence, and the claimant would be informed of the purpose of purchase of iron ore when it commences the raising of iron ore. In December 2009, the claimant came to know that the respondent clandestinely behind the back of the claimant had commenced operations of Ghatkuri mine without the knowledge of the claimant and without complying with the terms of the said agreement. The claimant, by its letter dated 24 December, wrote to the respondent that it had discreet information that the respondent was violating the terms of the selling agreement by selling the iron ore to some third party. The claimant called upon the respondent to let the claimant know of the correct factual position. In reply to the said letter, the respondent wrote on 11 January 2010, alleging that the said agreement was void ab initio, as it violated Rule 37 of Mining Concession Rules 1960, and referred to two letters dated 22nd June 2007 and 1st August 2008. It was further stated that as per the books of the respondent, a sum of rupees 1,67,50,000 was outstanding, and a check towards return of the advance has been issued under the cover of the letter of 1st August 2008. The claimant never received the purported letter dated 20th June and 1st August 2008, nor any check for 16750,000 or any other amount has been received by the claimant. The claimant contended that the said letters of 20th June and 1st August are forged and fabricated documents. The claimant, by its letter of 3rd February, categorically denied that it had received the respondent's letter of 22nd June 2007 and 1st August 2008, and the respondent had manufactured the said letters in attempt to wriggle out of the solemn selling agreement executed between the parties. The claimant also denied having received any check from the respondent. The respondent, by its letter of 15th February 2010, reiterated that the agreement was void ab initio and it was holding sufficient proof of delivery of alleged letters by the postal system. The claimant contends that at all material times it was ready and willing to perform its obligations in terms of the agreement, but has been denied by the reasons of wrongful breach and purported repudiation thereof by the respondent. The purported contention of the respondent that the said agreement is void ab initio amounts to repudiation and a refusal to perform the same. Moreover, the said agreement expressly recognized the right of the claimant to specifically perform the said agreement, since the iron ore is a subject matter of the agreement and is not an ordinary article of commerce, and compensation in terms of money would not afford adequate relief, which was expressly recognized in clause 12 of the agreement. In view of the fact that clause 14.1, it was unconditionally agreed between the parties that the respondent would sell entire iron ore excavated to the claimant alone and would not sell and or deal with any manner or form or directly or indirectly whatsoever with any other party, the claimant was entitled to a mandatory injunction directing the respondent to sell iron ore exclusively to the claimant for a period of 7 years. In addition to the specific performance, the claimant was entitled to damages on account of loss suffered because of the agreement envisaged payment of rupees 550 per metric ton for all grades of coal in lump and 250 per metric ton for iron ore fines. The respondent was selling the iron ore at much higher rate, and the claimant was suffering loss by way of differential amount and entitled to claim such loss in addition to specific performance. The dispute and differences between the parties and several proceedings were initiated in the Honorable High Court at Calcutta, resulting in appointment of an arbitrator. The claimant has claimed inter alia A, an award for specific performance of the agreement of 27 February 2005. B, mandatory injunction directing the respondent to sell exclusively to the claimant iron ore in terms of the said contract. C, perpetual injunction restraining the respondent from selling any iron ore raised from the said mine to any third party in any manner whatsoever, save and except to the claimant. And D, in addition to specific performance and injunction as above, an inquiry into the loss and damage suffered by the claimant in terms of para 20 hereof, and award such sum as may be found due and payable upon such inquiry. The respondent filed its counter statement of facts under cover of advocate's letter of 18th August 2012. During course of the proceeding, the claimant had adduced evidence through its witnesses. The respondent made an application for amendment of the counter statement of fact, by which filed by it for reasons of certain subsequent development. The said amendment was after contest was allowed on 15/11/2014. The respondent in its statement of defense had taken stand that there is no arbitration agreement between the parties, as the sale agreement dated 22nd February 2005 was void ab initio, and the agreement being an integral part of the sale agreement was incapable of being segregated therefrom. Therefore, the arbitration agreement is non-est and cannot be given effect to. The sale agreement violates Rule 37 of the Mining Concession Rules 1960. If the agreement was given effect to, then the respondent operation would be substantially controlled by the claimant, who is not a lessee of the state government for mining lease. The mining lease was granted in favor of the respondent. This would amount to subletting and indirectly transferring the mine lease and or the interest, right and interest therein. The respondent had entered into similar contract with Futuristic Steel Limited, and the Honorable High Court at Calcutta held that such agreement is violated Rule 37 of the Mining Concession Rules. Just prior to entering the agreement with the claimant, the respondent on that day entered into an agreement with Metsil Exports Private Limited, which was raising agreement with the respondent. The respondent pleaded that the scheme of the two agreements, that is the raising contract and the sale agreement, were structured in such a manner that the two agreements were inextricably intertwined. No effect would be given to one without the other. According to the respondent, the entire possession and control of the mine of the respondent was taken over by the claimant and the raising contractor Metsil, which was and still is the company under the control of the claimant. Metsil was to extract the mines, minerals, iron ore, which was to be delivered to the claimant. The respondent was to get a small premium of rupees 200 per metric ton and of ores and rupees 100 per metric ton for fines. Apart from violation of Rule 37 of the Mining Concession Rules of the said agreement is hit by Section 23 of the Indian Contract Act, as the agreement was forbidden by law. The whole purpose was to defeat the provisions of law of the country, and hence both sale and the raising contract were opposed to public policy and void ab initio. The respondent had stated that both Metsil and Synergy were under common control, management and control by Santosh Kumar Sharma and Suresh Kumar Sharma. The balance sheet of the claimant was signed by Santosh Kumar Sharma and Suresh Kumar Sharma, and auditors of both the companies were the same. The electronic mail address of the claimant and Metsil are also similar. Therefore, the agreement is vitiated by fraud, and the claimant is not entitled to derive any benefit therefrom. According to the respondent, the sale agreement is incapable of giving effect to unless obligations under the raising contract was performed by Metsil. The raising contract was terminated on 22nd June 2007 and has been accepted by Metsil. Therefore, the sale agreement cannot be given effect as to the obligations to sell iron ore was dependent upon iron ore raised by Metsil. Therefore, the sale agreement is incapable of being performed and frustrated, and the parties are discharged of all obligations thereunder. Both the sale agreement were for all purposes coextensive and coterminous and incapable of being performed separately. According to the respondent, the claim of the claimant is ex facie barred by limitation, and the invocation of arbitration agreement dated 22nd August 2011 was beyond the period of 3 years from the date when the cause of action arose. The cause of action arose in favor of the claimant latest on 25th June 2007, when the claimant received or deemed to have received the notice sent under cover of letter of 22nd June 2007, written by the respondent, informing the claimant that the sale agreement could not be given effect to as being void and was terminated. The disputes and claims in the arbitration were otherwise barred by law and incapable of settlement by arbitration. Mediation is a necessary party and there is no common arbitration agreement. The sale agreement is void for mistake, and clause 12 of the sale agreement was induced by mistake. The report of Indian School of Mine show that iron ore sold domestically and exported from February 2005 to state that millions of tons of iron ore were traded regularly. The respondent contends the sale agreement is incapable of being specifically performed in terms of specific relief act, since A, damages is more than adequate remedy. The contract is determinable in nature. Contract runs into numerous details which arbitral tribunal cannot enforce specifically of its material terms. Contract is dependent on violation of parties. The contract involves performance of continuous duty which no arbitral tribunal can supervise. Since specific performance is a discretionary relief, it is not to be granted. The claimant itself is in breach of the terms since it has not set up any sponge iron plant in the state of Jharkhand for use of iron ore as referred to in clause 12. The claimant cannot make any claim on basis of the illegal contract such as sale agreement. The mining and lease of the respondent has expired by a flex of time on 8th February 2006, and thereafter the respondent carried on the mining activity in terms of Rule 24A6 of the mining concession rules. The government of Jharkhand, by its letter of 22nd October 2014, in principle approved second renewal of the mining lease in Ghatkuri area and have imposed a certain condition that all materials extracted in iron ore would be captively consumed by the respondent. As a result of the respondent's position, the sale agreement was void and cannot be given effect to, as the respondent is not permitted to sell iron ore but to use it captively. Therefore, the sale agreement is rendered void as a contrary to the terms of the mining lease. The sale agreement is incapable of and impossible of being performed as would violate the conditions of the mining lease. Therefore, the sale agreement stood frustrated. In 2007, no mining activities had commenced as the mines and both Metsil and claimant abandoned the raising contract and the sale agreement. Both were in repudiatory breach of the contract, which were accepted by the respondent, bringing the contract to an end on 22nd June 2007. The respondent had issued letter on 22nd June 2007 terminating the sale agreement, and the claimant did not contest the said position of termination of agreement by the respondent. On June 22nd, 2007, similar letters were sent to Monet Ispat, BK Coalfields Limited in respect of similar agreements which were received by them. The claimant had received the said letter of 22nd June in Delhi on 25th June and made the demands for compensation. According to the respondent, several meetings were held between the directors of the claimant and the respondent in Delhi, and the claimant accepted the sale agreement was void ab initio. The respondent made several attempts to return the amount of ₹167,57,000 which had been paid by the claimant to the respondent as advance, but the claimant refused to accept the same. The respondent proceeded on basis of all the issues relating to the sale of the agreement had been closed out. The respondent made application on various governments to commence mining operations, and working permission was obtained by the respondent on 21st August 2008. The respondent thereafter commenced sale of old stock of iron ore available in the mines, and full-scale mining operations commenced by April 2009. The respondent was shocked to receive the claimant's letter dated 24 December 2009 that the respondent is in violation of the sale agreement, commenced supply of iron ore to third party. The respondent replied stating that the sale agreement is void, contrary to mining concession rules, and the reference and referred to the letters of 22nd June 2007 and 1st August 2008. The claimant denied of having received the said letters. In the statement of defense, the respondent has pleaded exchange of correspondence between the parties, where the respondent is accusing the claimant of taking a completely dishonest stand to suit its maleficent intention. On 22nd August 2011, claimant invoked the arbitration agreement and demanded specific performance of the contract. The respondent herein has denied the allegation. Then, my lord, section 9 proceedings have been stated, my lord, and my lord kindly comes to paragraph 43, where the issues were framed by the sole arbitrator.
Yes.
The issues, my lord, on basis of the above pleadings, the following issues were raised in the third sitting. 1. Is there any valid and subsisting arbitration agreement? 2A. Whether the sale agreement is void ab initio. B. Is the sale agreement in violation of Rule 37 of the Mining Concession Rules 1960 as contended by the respondent? 3. Is the sale agreement enforceable on its terms? 4. Was the claimant in breach of the terms and conditions of the sale agreement? 5A. Was the sale agreement terminated by the respondent? B. If so, to what effect? C. Whether the letters dated 22nd June 2007 and 1st August 2008 are genuine documents? 6. Are the claims raised in the statement of claim or any part thereof barred by limitation? 7. Is the claimant entitled to specific performance? 8. To what relief, if any, the claimant is entitled? 9. Costs. So these were the issues which were framed.
Yeah.
Now, we'll find these issues from paragraph 61 onwards. Paragraph 44 to 60 is a submission of Mr. Mukherjee,
Yes.
which for the moment I'll skip because I'll come back to the submissions later on because I'll take my lot to the findings of the learned sole arbitrator. So paragraph 44 to 46 are the submissions made by Mr. Mukherjee.
Yes.
44 to 60 record the submissions of the claimant.
Yes.
Paragraph 61 only, one paragraph only submission of the claimant of the respondent is recorded. 61 is my submissions.
Yes.
Para 61, the respondent submission. And claimant's reply in 62, and the decision, my lord, will find from paragraph 65 onwards.
65.
Yes, the finding, the decision of the tribunal starts at paragraph 65 to 91.
Yes.
At page 72. It will just give me a moment. Give a second left. Yeah. My lord, at page 72, my lord will find, my lord, the decision, paragraph 65 onwards, my lord. The facts have been set out above, and the same is not being repeated. 66. I have heard the submission of the counsel appearing for both the parties, and I have considered the exhibits evidence adduced by the parties. I shall first take up the preliminary issue raised by the respondent that the sale agreement dated 27 February 2005 violates Rule 37 of the mining concession rules, which is issue number 2 and 5.
Yes.
The learned Advocate General strongly submitted that this question has been decided in several cases, including the decision rendered by the Honorable Division Bench of the Honorable High Court at Calcutta in this matter between the parties. Learned AG submitted that the respondent and claimant are two separate and distinct entities and not alter ego of each other as contended by the respondent. Commonality of directors and shareholders does not lead to the conclusion that any decision of one entity is binding on the other or alter ego of the other. At this juncture, it is useful to set out rule number 37 of mining concession rule, which is set out. Kindly allow me to place rule 37. Transfer of lease. The lessee shall not, without previous consent in writing of the state government, and in the case of mining lease in respect of any mineral specified in Part A and Part B of the first schedule to the Act, without previous approval of the central government, A, assign, sublet, mortgage, or in any manner transfer the mining lease or any right, title, or interest therein. Or B, enter into or make any bona fide agreement, contract, or understanding whereby the lessee will or may be directly or indirectly financed to substantial extent by or under which the lessee's operations and undertakings will or may be substantially controlled by any person or body of persons other than the lessee. Provided further that where the mortgagee is an institution or bank or a corporation specified in Schedule 5, it shall not be necessary for the lessee to obtain such consent from the state government. The state government shall not give its consent to transfer of mining unless the transferee has accepted all conditions and liabilities which the transferor was having in respect of such mining lease. 2. Without prejudice to sub-provisions of sub-rule 1, the lessee may transfer his lease or any right, title, or interest therein to person who has filed an affidavit stating that he has filed an up-to-date income tax return, paid the income tax assessed on him, and paid the income tax on basis of self-assessment as provided in the Income Tax Act 1961, or on payment of fee of 500 rupees to the state government, provided that the lessee shall make available to the transferee the original certified copies of all plans of abandoned working area in the belt number 65. Provided further where the mortgage is in bank, this is not relevant, provided further that the lessee shall not charge or accept from the transferee any premium in addition to the sum spent by him in obtaining the lease and for conducting all or any of the operations referred to in Rule 30 in or over the land leased to him. Then 37A, transfer of lease to be executed within 3 months. Wherein on an application for transfer of mining lease under Rule 37, the state government has given consent for such transfer of such lease. A transfer lease deed in Form O or a form as near thereto as possible shall be executed within 3 months from the date of the consent or within such period as the state government may allow in this behalf. Para 67. In support of his submission, Learned AG relied upon the decision reported in 2010 5 SCC 306. The Apex Court held it was not in dispute that Subhuti and Indus Ind are two independent companies incorporated under the Companies Act 1956. It is further held that each company is a separate and distinct entity, and mere fact that they have common shareholders and a common board of directors, the two companies are a single entity. Existence of common shareholders and directors cannot lead to an inference that one company would be bound by the acts of the other. Honorable Division Bench of the Honorable High Court at Calcutta, in dispute between these parties, in the reference they also came to the same conclusion that commonality of directors and shareholders does not make one company an alter ego of the other. Learned Counsel for the respondent took great pains to show that Metsil, raising contractor, and the claimant have one and same identity. He submitted that the two companies were controlled by the same group of shareholders, and on conjoint reading of the Metsil's agreement and the claimant's agreement would show that there is a violation of Rule 37(1)A and 37(1)B. The entire mining and operation and financing were controlled by Metsil, and the claimant and the said companies are one entity. The said two companies entered into two agreements on the same day at the same place, and it is evident that the two agreements form part of this same intended transaction, which evidently contravenes Rule 37. Even otherwise, the claimant's agreement, if read on its own, violates Rule 37(1)A and 37(1)B. Opposing such submission of the respondent, Learned AG showed that in the recital, the respondent has approached the claimant with a proposal to exclusively sell the entire iron ore excavated by its raising contractor on their behalf from the leasehold area. He also refers to clauses 3.6 and 3.7, wherein it states that the claimant has all rights to receive the excavated iron ore raised by the raising contractor through OMM. The claimant would have exclusive right to deal with the ores purchased from OMM as it deems fit. Clause 4 clearly demonstrates that all transactions would be between the claimant and the respondent, and the raising contractor Metsil has no role to play. Learned AG submitted that there has been a violation of Rule 37(1)A(B), and there has been no assignment, subletting, mortgage, or transfer in the mining lease or assignment of any right, title, or interest therein. He also submitted that Rule 37(1)B contemplates that financing has to be to a substantial extent, and this has not been proved by the respondent. Any provision for advancing small amount to be adjusted subsequently would not amount to financing substantially. He referred to the award Exhibit C35 rendered by the London arbitrator in Justice Lahoti. The respondent has disputed with Adhunik Steel Private Limited. The respondent had an agreement with Adhunik for raising manganese ore on its behalf. The respondent issued notice of termination of the said agreement, and one of the grounds was that the respondent realized that the contract it had entered with Adhunik Steel was in violation of Rule 37 of the mining concession rules. The district court and the high court prima facie came to a conclusion that the rule had no application. The matter went up to the Supreme Court. The Supreme Court appointed Justice R.C. Lahoti, former Chief Justice of India, to adjudicate the dispute within the parties. The agreement between the respondent and Adhunik was a period of 10 years with an option of renewal, and the Adhunik was granted right for extraction and excavation of iron ore of the mines of the respondent. As stated before, the respondent terminated the contract on the ground it was in violation of Rule 37. The first issue before Justice Lahoti was whether the agreement dated 14th May entered into between Adhunik and the respondent was violated Rule 37. It appears that a similar defense was taken by the respondent before the said learned arbitrator. After considering all the terms and conditions, Justice Lahoti came to a finding that the agreement dated 14th May did not violate Rule 37 of the mining concession rules. The terms of the contract were similar to the present agreement. On the same day, 14th May 2003, the respondent entered into a selling agreement with Futuristic Limited to exclusively sell and Futuristic Steel to purchase the entire manganese excavated by Adhanik from the mines of the respondent. The respondent agreed not to sell or dispose manganese ore excavated by Adhanik to any other party. In the case at hand, respondent entered into a contract with Metsil for extracting iron ore, and the same date entered into an agreement with claimant for selling the iron ore exclusively to the claimant and not to any other person. Futuristic also paid 2 crores advance and agreed to make further payment of 60 lakhs. On 24th November 2003, a respondent purported to terminate the selling agreement. Futuristic invoked arbitration and the Honorable High Court at Calcutta referred the dispute to Honorable Justice Shishitosh Mukherjee. During the pendency of the arbitration, the claimants amended the SOC and prayed for specific performance of the parties. OMM filed counter statement, and main defense of the before the arbitrator was the agreement between Futuristic and OMM was violative of Rule 37 and therefore null and void. The principal point before the arbitrator was whether the agreement of Rule 37(1). Secondly, the claimant was entitled to specific performance of the injunction. The respondent urged that before the arbitrator that the advance paid by the claimant established that the respondent OMM was directly or indirectly substantially financed by the claimant. After considering the terms of the relevant provisions of the rules, that there was no financial agreement or for control of the respondent's undertaking or operation, the learned arbitrator came to the conclusion that the selling agreement was only for sale and purchase of the agreement and not a financial agreement, and it did not directly or indirectly give the claimant control over the operations of the enterprise of OMM. The learned arbitrator relied upon decisions reported in AR 1996 Calcutta 67. Arbitrator held the ratio of the decision rendered in 96 Calcutta fully applied in favor of the claimant. The arbitrator granted an award, specific performance, and permanent injunction against OMM from giving effect to or further effect to OMM's letter of 24th November. The arbitrator held the agreement between the claimant did not violate 37(1)(a)(b) of rules. It appears that the respondent has been taking the plea of Rule 37 in every forum and making a defense that the agreement is illegal, null, and void as violative of Rule 37. In 96 Calcutta, similar case arose between Vijaya Minerals and Vikash Day. The terms are very similar and the agreements in the case at hand. Mr. Mukherjee, learned AG, is right to rely upon the set 2 awards and AR 96 Calcutta 62 buttress the submission the selling agreement between the parties does not violate Rule 37(1)(a) or (b). The award of Justice Shishitosh Mukherjee being Exhibit C20 and the award of Justice Lahoti, Exhibit 35, are valuable precedents. In that view of the matter, I hold issue 2A and 2B in favor of the claimant and against the respondent. Before parting, with regard to the violation of Rule 37, I wish to add that the claimant's counsel has repeatedly submitted that the agreement is void ab initio as violative of Rule 37. In this context, I have asked learned counsel that if the respondent knew the agreement the respondent was entering into was void, then why did the respondent enter into the agreement at all? The claimant is not admitting that the agreement is void, but the respondent is alleging that the agreement is void. To this, respondent submitted that it came to learn that later that the selling agreement violated Rule 37, and as soon as thereafter the respondent gave a notice of termination. In para 40 of the counter statement of the facts, the respondent pleaded that the respondent was advised that the sale agreement was and raising a contract were forbidden by law and in particular MC rules. Accordingly, the respondent terminated the contract with the client. I am unable to accept the respondent being in mining business did not know at the time of entering into the sale agreement that the sale agreement is violated Rule 37. I hold that the respondent was aware that the agreement did not violate Rule 37 and willingly entered into an agreement for sale with the claimant. The respondent has been raising frivolous grounds to scuttle the agreement which the respondent solemnly entered. It is unbelievable that any party who would enter into agreement knowing that it is an illegal agreement, and if it does so, it will do it at its own risk. The respondent has cited these judgments, which are then issue para 76 at page 80. The next issue is
so with regard to this,
the tribunal holds
7
is not violative because principally 2 reasons: that these are 2 different entities, and would common shareholder or common directorship would not mean that they are same in one. And secondly, the agreement did not appear to show that they have substantially financed my entity. So on these two counts, my lord, the arbitrator held, of course, relying on the two awards, that it's not violated. My lord. I'll make my submission on this aspect, my lord. I'll just taking my lord through the award. My lord. Page 80, then my lord, the issue number 5 is taken. My lord, there's a 11:30 matter fixed, my lord. So I can, or should I come back, my lord? Wait a minute.
Come back. I will give fix another date.
That's why we are always ever grateful.
Sense suffering for the petitioner, sense suffering for the respondent. Counsel for the petitioner argued at length, but due to paucity of time, hearing could not be completed. Fix, give the date. Monday है? Fix है? हाँ. Monday? 3 p.m.
This Monday. My lord, Monday I'm not here, my lord.
Yeah. वैकेशन के बाद ही देखो जून में क्या जून में कोई डेट है 11:30 again the border 9 June at 9th June 11:30
11:30. Very well.
Hello, on behalf of defendant number 6 and 7, madam, we are filing our note. We are required to file a note. We've tried to keep it as short as possible, but considering the extensive arguments, we've dealt with it as precisely as possible. Madam.
yes
They will start. Defendant number 10. 10.
Oh, I was under the impression 6, 7 will be separated, disposed of in view of that appeal court's order.
yes
Sir, Judge, sir.
For defendant 10. But before my learned senior friend proceeds, only one submission. Two of the defendants, not my learned senior friend's client, two of the defendants have filed applications for vacating of the order. They have not filed any affidavit in opposition. So, if your lordship kindly grants us time, let the hearing go on. I am not standing in the way. Yes, I am not standing in the way. But let the hearing go on. Kindly gives us some time to use an affidavit to their application.
I appear for defendants 8, 9, 13, and 14 who filed the application.
for vacating
No, let the hearing go on. I'm not standing in the way.
okay
For 1 year they have filed.
6, 7 also.
No. I have with approval.
6 7 8 9 10
No.
He's wearing different hats, brother. He's wearing different hats, like all the defendants.
7 8 9 10
But I am for
nine-
this 8, 9,
13 and 14.
I am for the defendant number 1, 2, 3, and 5. I have filed an application under section 45.
Yes, that is there. In that pleadings are complete.
completed
Yes.
My lord,
But
may I,
his application by the defendant was 8, 9 kindly gives us time to use.
okay yes
my lord, since your lordship has extensively heard and the hearing is complete, so for a 6 and 7, now the affidavits will be exchanged. So the entire, me, Mr. Thakkar, we've completed on 5 and 6 and 7.
Let them withdraw their application. What can I do? If they file their
No,
application.
I am not on that. I am saying
no,
so
in
for a
that case
6 and
who has
7.
filed the vacating application so vacating you have not filed the affidavit in opposition so vacating application be treated as affidavit in opposition and the matter can be
And grant us time to use a reply to that. We shall come back on.
Then what is the
and you already filed you are Mr. Bhattacharya you asked for the 10
Yes,
Yeah, for the
opposition file to which we have filed the reply.
okay. And with the, what about one you have not filed the affidavit in opposition you have filed in only 45
Affidavit in opposition also
Filed.
filed. Also filed.
okay let continue
That's so then the conclusion of hearing all the effort that your lordship has put in the time, so
Correct.
that will become a waste in on 6 and 7 is totally separate from the
Okay,
other defendants.
let Mr. Bhattacharya continue. I
Yes,
will
sir.
pass.
So-
Who has passed? I will take note of it. Who has filed an application vacating
Then
that
I
we
got-
treated as affidavit in opposition
Yes,
in
absolutely.
connection with the injunction application. He will in the meantime he will file the reply. Let me hear Mr. Bhattacharya.
very brief, my lord. I am the worst sufferer because my money is stuck and the goods belonging to me is also stuck.
If you're taking the responsibility of all, then I will release all.
No. I will be very brief. 10 minutes, my lord, not more than that.
Now, that's if you're taking the responsibility of all, then I will release all. So you fight with the plaintiff.
No. I am the worst sufferer. My lord, your lordship will see the pleading
Okay.
at page 51, paragraph 83
51
of
हाँ, बताए.
volume 1, my lord. J1.
J1.
Yes.
J1.
Page 51.
Just a minute. Yes.
Paragraph 83. The defendant numbers 1, 10, 11 and 13 delivered 6 consignments to the plaintiff.
51.
Yes, ma'am. 51, page 51, paragraph 83.
83. Yes.
1, 10, 11 and 13 delivered only 6 consignments.
Yes.
The consignment, so far as I am concerned, is at page 52. My lord, defendant number 10, fourth contract. Now, my lord will kindly find this bill of lading. This bill of ladings are at page 256 and 2. Sorry. Oh. 256 and 257, which are at pages, which is at volume 3.
256, 257.
My lord.
Yes.
My lord will kindly see at the top the shipper.
You are 1. You are 10.
I am 10.
You are 10.
My name is Sham Ferro.
Correct.
My lord will kindly see the shipper at the top. Apocalypse. That's the defendant number 1.
Yes.
Consignee is Duvartham, which is the plaintiff. I am no way concerned. There is no privity of contract between the plaintiff and the defendant number 10. 256, 257. Not a scrap of document has been shown to your lordship that there has been any privity of contract between us. Rather, I have disclosed the bills which are with the defendant number 1, and he did not pay me. Now, my lord, so far as the prayers are concerned,
Yes.
my lord, he has sought for.
So this is only against you.
My lord,
This
this
is
is only against.
this
These
is
are the other.
Paragraph 83 only.
83 only. Rest they have said collusion, conspiracy.
Regarding document, you are
Yes, this is the only one.
correct.
Now, my lord, the prayers. Now, my lord, he has sought for prayer F. My lord, prayers D, E.
125,
No, my lord, prayers C. First is prayer B and C.
A. No, B, you're not there.
Yes, an order of injunction to deliver the goods.
An order of injunction directed defendant 1, 2, 5, 7 and 10.
Yes, that's me. 10. Because the goods are
okay.
mine.
110. 110. That is prayer A, B.
My lord will kindly see prayer C is in the alternative. He cannot have both the prayers. E, he has got E and F as well.
C, yes. F, B and F.
Now he says the contract was induced by fraud. Fraud, it has to be avoided. Now, my lord kindly takes section 19 of the Contract Act.
Yes.
When consent to an agreement is caused by coercion, fraud, or representation, the agreement is a contract voidable. First of all, I say there is no agreement with me. At the option of the parties whose consent was so caused. A party to the contract whose consent was caused by fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed, and that he should be put in the position if he would have been if the representation made had been true. Now, your lordship kindly takes illustration C to this section. A fraudulently informs B that the A's estate is free from encumbrance. B thereupon buys the estate. The estate is subject to mortgage. B may either avoid the contract. He cannot do both. He can say, give me the money or give me the goods. He cannot say both. Or may insist on it being carried out and the mortgage date redeemed. He cannot ask for both. Both the prayers cannot be. These are self-destructive case which the plaintiff has done. Now, my lord will kindly recall that how, on what basis the 12A leave was obtained, which is in the plaint, my lord. Volume 4 of the plaint. My lord, having volume, I'm sorry, my lord, I stand corrected. Volume 4 of the petition is the plaint.
Volume 4.
My lord, they filed a criminal complaint way back in 2021. Because the delay, your lordship will kindly consider the delay and the balance of convenience, my lord. Paragraph 162. Section 41.
Yes.
There is extreme urgency in the matter, as the defendant number 10, that is my client, has filed an application before the learned Additional Chief Judicial Magistrate, Shialda, for lifting of the order of attachment. Order of attachment and release all 6 containers stuffed with goods, and the defendant number 10 has received payments for these goods as pleaded above. The defendant number 10 is not entitled to have possession. In the event the possessions belonging to the plaintiff were handed over to the defendant number 10 by the police, it would cause, well, this is basically asking a civil court to stay the proceedings before the criminal court, which is barred by section 41E of the Specific Relief Act. So I'm sorry, not E, my lord, A.
Section?
My lord will kindly. 41A. Lord, these powers, your lordship is aware, if they are aggrieved by it, they can file under section 397 of the CRPC or a 482 application. An FRT has been given, which I have disclosed in my affidavit in opposition. They have filed a narazi till date, no steps taken. And
which section you are
section 41A from prosecuting a judicial proceeding at the institution.
Specific relief?
Yes, my lord. My lord, D, to restrain any person from instituting or prosecuting any proceeding in criminal matter. So this is in the criminal court I have filed. My rights which I have. Showing this ground, he has invoked the jurisdiction of my lord. Opposition. Opposition কোথায় এটা এটা আমাদের opposition তো Now, if your lordship kindly takes my affidavit,
Yes.
my lord, takes my affidavit in opposition, my lord, page affirmed by one Arup Noshkar. Bullshit.
Yes.
109 is my application. This is my application for release of goods under section 457 of the CRPC.
$109.
109, my lord. My lord will find de facto complainant, respondent number 3. That is the plaintiff before my lord.
Yes.
And all these transactions happened in 2021.
This application filed by you?
Yes, my lord. 108, my lord, will kindly see the cause title, Shamfero Alloys Limited, applicant.
Yes.
My lord will kindly take
Yes.
the prayers at page 113.
Correct.
And my
Release
lord,
of the goods.
and the FRT, my lord, which has been given, the relevant portion, page 120, last paragraph. Need a better copy. Several persons, my lord, we have called it out in our notes, my lord, that may be submit on Monday.
No
Because
problem.
I
I will
don't
take
have a
note.
print.
No problem. Yes.
Several persons from the office and factories of the company, namely Shamfero Alloys, were examined. While it would be ascertained that they had business relationship with Apocalypse, that is the defendant number 1, for a very small tenure, and none of them were acquainted with the company, namely Apocalypse Steel Power. It could further be learned that from them that in spite of several persuasions, the accused company failed to make payment within the scheduled time. Investigations also reveal that not only Shamfero but also the other companies from where the accused company, namely Apocalypse Steel and Power, purchase materials, experienced the delay payments by the accused company, namely Apocalypse, during their business tenure. Several email communications were found from Shamfero to the accused company, asking them to clear the dues. There is also a mention here that none of these companies, including the petitioner, namely Shamfero Alloys, had any transaction with the complainant company. As would appear, then, my lord, finally, the police, my lord, I do not say that this is binding on your lordship, my lord. At page 122, nothing could be substantiated. And to stop the release of the goods which I had filed, the application which I had filed pursuant to this report, to have the release of the goods, they came and filed this suit after after 3 years from the date their cause of action arose.
So what has happened to this application?
This is still pending. Lord, your lordship is aware, my lord, the courts below, my lord, since the matter is pending before your lordship, the courts below, my lord, are reluctant and or hesitant. No doubt, the only judgment I would like to cite, my lord, I had cited at the ad interim stage also, though this was in relation to a Central Sales Tax Act, but the meaning of sale given in this act was held to be akin to Section 5. So my relationship with defendant number 1 would not create an automatic privity with the defendant number, with the plaintiff. My lord, it is a judgment reported in 1975, 2 SCC, page 47. My lord, paragraphs 25 and 26. Sale of goods act. Before that, my lord, if I may, my lord, if your lordship kindly takes the Sale of Good Act once, because I want to show what is the definition of sale. And copy Sale of Goods Act.
Yes.
A contract of, I'm sorry, section 5. A contract of sale is made by an offer to buy or sell goods for a price and acceptance of such offer. The contract may provide for immediate delivery of goods or immediate payment of price or both, or delivery or payment by installments, or that delivery or payment shall be postponed. Where is the document that this is such a contract has been made between the plaintiff and the defendant number 10, where he has agreed to pay and I have agreed to deliver it to him? Not a scrap of document shown.
Yes. Yes.
Now, my lord, apropos this, if your lordship kindly takes paragraphs 25 and 26 of this report. The contention on behalf of the appellant that the contract, similar contention, that the contract between the appellant and the corporation and the contract between the corporation and the foreign buyer formed integrated activities in the course of export is unsound. The crucial words in the section are the sale or purchase of goods shall be deemed to take place in course of export of goods only if the sale or purchase occasions such export. The various decisions to which reference has been made illustrate the ascertainment of the preeminent question as to which is the sale or purchase which occasions the export. The Coffee Board's case as well as the case of Binani Brothers clearly indicates the distinction between sale for exports and sale in course of export is never to be lost sight of. The features which point with unerring accuracy to the contract between the appellant and the corporation on one hand, and the contract between the corporation and the foreign buyer on other hand, that is the plaintiff and the defendant number 1, are on the other, as two separate and independent contracts of sale. While the ruling in Coffee Board's case and Binani Brothers' case are this: the corporation entered on the scene and entered into a direct contract with the foreign buyer to export the goods. The corporation alone agreed to sell the goods to the foreign buyer, which is the defendant number 1. To the foreign buyer. The corporation was the exporter of the goods. Your lordship has seen the bill of lading. It was the defendant. There was no privity of contract between the appellant and the foreign buyer. The privity of contract is between the corporation and the foreign buyer. The immediate cause of movement of goods and export was that the contract between the foreign buyer, who was the importer, and the corporation, who was the exporter and shipper of all the goods. All the documents were in the name of the corporation, which is the defendant number 1, whose contract of sale was the occasion of. The expression occasions in section 5 of the Act means the immediate and direct cause. But the contract between the corporation and the foreign buyer, there was no occasion for export. Now, my lord kindly skips over the page to paragraph 27.
Yes.
The expression sale in section 5 of the Act, this was with regard to sale of goods, some central sales tax act, has the same meaning in the Sale of Goods Act. String contracts or chain contracts are separate transactions, even when there is a similarity relating to quantity, quality of goods, shipments, sampling, analysis, payment, and force majeure, or other terms. A contract for sale is a contract whereby the seller transfers or agrees to transfer the property in the goods to the buyer for money consideration called price. There were two separate contracts. The price was different in two contracts. This difference also dissociates the two contracts from each other. So where is the privity of contract?
Yes.
How am I to be held responsible? He knows that he cannot recover anything from the defendant number 1, and that's why this story has been spun, because all these companies have a huge turnover and he thinks he can extract it from us. My lord, may I file my notes on Monday, my lord? As my notes are ready, it's just that the print has. Grateful, my lord.
Yes, anybody other?
Yes, your lordship. I'm appearing for the respondent numbers 11 and 12. I'll very briefly supplement what has been submitted by my learned seniors.
Yes.
I will go. But 1, 2, and 5. So allow me to. No, I can say 5 and 10.
11 and 12.
11 and 12.
So far as
Yes.
Yes, your lordship. Your lordship by now is completely conversant with the structure of the entire transaction. Certain defendants who are really suppliers, who are really manufacturers of the subject contracted goods were contacted by the defendant numbers 1 to 5. Defendant number 1 principally, 2 to 5. Who in turn had a separate contractual obligation vis-a-vis the plaintiff. The entire argument of the plaintiff and the entire basis on which the prayer of the interim relief was pressed for was that there is a separate undertaking of some performance obligation, delivery obligation by these separate defendants who are really manufacturers vis-a-vis the plaintiff. That is the sum and substance, that is the substratum of the claim of the interim relief. Now, insofar as the pleadings are concerned, an endeavor has been made to create some illusion by crafty drafting to say that we had undertaken, the defendant numbers 11 and 12 had undertaken some kind of obligation vis-a-vis the plaintiff. This is by and large the case. Now, before I commence my submissions, I will just caveat my party, the party I'm representing, defendant numbers 11 and 12, by saying that the defendant numbers 11 and 12 perhaps stands in a slightly different position vis-a-vis defendant number 6 and 7. Because the involvement of the defendant number 6 and 7, 6 specifically, is right from the inception at the time of the trial order of the first contract, 216 metric ton. And they say that there were negotiations, their senior marketing manager directly participated in a Zoom call, etc. I will not detain your lordship with the specific paragraphs. I will just give the references. Vis-a-vis the defendant number 6 is concerned, insofar as defendant number 11 and 12 are concerned, it is very important to note the case of the plaintiff vis-a-vis the defendant number 6 and 7 cannot at all sustain against defendant number 11 and 12. What was the case that was sought to be made out by the counsel of the plaintiff? The case was, but for the representation made by the defendant number 6 and or its representatives at the initial nascent stage of the transaction, at the time of the trial order, first contract, they would not have embarked upon this entire transaction. And initially, defendant numbers 11 and 12, and specifically defendant number 11, which is the manufacturing company, was nowhere in the entire frame. Initially, the supply obligation did not at all envisage any supply by defendant number 11. Defendant number 11's involvement comes in only at the stage of the 5th contract and the 7th contract upon failure, upon alleged failure as averred by the plaintiff of certain other suppliers to fulfill the delivery obligations. In this regard, I'll take your lordship very briefly through the pleadings just to substantiate the nature and character of the involvement of the defendant number 11. Your lordship will kindly come to para 53 of the petition, GA1. This is at page 30. Because it has never been anybody's case that defendant number 11 was in the fray right from the inception.
Yes.
May I read?
Para 53.
Para 53.
Yes.
During this time, the plaintiff and the defendant number 1 negotiated for purchase of 2,700 metric tons of high carbon ferromanganese, and so as to record the price, the defendant number 1 raised an invoice bearing number so and so. The defendant number 1 claimed that the goods would be procured procured by it from the defendant number 6 and defendant number 11, hereinafter referred to as the fifth contract. And if your lordship,
Yes.
kindly, very briefly, now your lordship will straight away come to para 53, I have shown, para 61. I'm skipping the other references to the other pleadings. I will refer to them in my written notes.
Para 61.
Para 61.
Yes.
I will read from para 60 just for continuation. Mr. Ali held a meeting with the directors of defendant number 1, namely defendant numbers 2, 3, 4, and 5 on 14th January 2021 at the meeting room in the business center. Meeting room at the business center of the Oberoi Grand Hotel at 15 Jawaharlal Nehru Road, Kolkata, within the jurisdiction of the Honorable Court. Copy of the summary of the invoices, Oberoi Grand Hotel, so and so. 61. This is very important. In course of discussions, Mr. Ali expressed the plaintiff's concern about the delay in delivery of the materials in spite of the plaintiff having made advance payment in excess of 644,715 euros. The defendant numbers 2, 3, 4, and 5 represented to Mr. Ali that the monies advanced by the plaintiff had not been retained by the defendant number 1, and a substantial portion of the same had already been paid to defendant number 6 and 8 for procuring materials from the said defendants. This was the initial understanding. The defendant numbers 2 to 5 further represented to Mr. Ali that defendant number 8 was not able to supply the balance material under the third contract, and the same would be supplied by defendant number 13.
Yes.
The defendant number 2 to 5 further represented. This is what is important insofar as defendant number 11 is concerned. Defendant numbers 2 to 5 further represented that they had negotiated with defendant number 1 for supply of 9,000 metric ton of high carbon ferromanganese being part quantity of the fifth contract, and the entire quantity of the proposed seventh contract. Yes. The balance 1,000 metric tons under fifth contract would be supplied by defendant number 6. And the entire quantity fourth contract and the proposed sixth contract would be supplied by defendant number 10. The defendant numbers 2 to 5 told Mr. Ali that he could carry out inspection of the factories of each of the defendant numbers 6, 10, 11, and 13 to ascertain for himself the manufacturing facility of each of the said defendants. So this is not a scenario of the transaction from the very inception envisaging supply or procurement by widest of amplitude, procurement from defendant number 11. It is due to some alleged shortfall in the fifth contract that defendant number 11 is considered today. And defendant, insofar as defendant number 11 is concerned, defendant number 11's obligations are confined to part of the fifth contract and entirety of the seventh contract. Now, your lordship kindly notes this fifth contract and seventh contract had already been executed in December 2020. I had just shown your lordship para 51.
Yes.
The fifth contract had already taken place in 14th of December 2020. Yes. So as at the date of all of this allegations, all of this negotiations referred to in para 60 and 61 between defendant number 1 and defendant number between defendant number 1 and the plaintiff, the subject contract had already come into existence. Now, in this view, your lordship will straight away come to 62 and 63. Insofar as the defendant number 11 is concerned, those really are the relevant paragraphs, paras 61 to 63. In or about the third week of January 2021, the defendant numbers 2 and 3 accompanied Mr. Ali to the factory of the defendant number 11 at Purulia outside the jurisdiction of the aforementioned court.
Yes.
So visits in third week of January 2021. At the factory of the defendant number 11, Mr. Ali was introduced to defendant number 12, who represented himself as a director of defendant number 11. in the discussions which took place between the plaintiff, the defendant numbers 2 and 3, and the defendant number 12 at the factory of the defendant number 11, defendant number 12 was joined by several other persons who, according to the defendant number 12, were looking after the production and the marketing of the products manufactured by defendant number 11. In course of such meeting, the defendant number 12 informed the plaintiff that the defendant number 1 had placed an order on the defendant number 11 for supply of 1700 metric ton of high carbon ferromanganese, and defendant number 11 had already commenced manufacturing of the goods. The defendant number 12 also represented that the defendant numbers 1 and 11 had negotiated rates for another consignment of 7300 metric ton of high carbon ferromanganese. The defendant number 12 further represented that defendant number 11 was facing financial crunch due to COVID pandemic and manufacturing was delayed as the defendant number 1 had not made any advance payment. Now, perhaps the next lines are what is the basis of the representation, the case of the representation sought to be made out by the plaintiff. The defendant number 12 requested Mr. Ali to make advance payment to the defendant number 1 so that the defendant number 1 could forward the same to the defendant number 11, and on receipt of such advance, the defendant number 11 would commence delivery of goods to the plaintiff through the defendant number 1. This is the representation they have relied upon. Now, I have 3 submissions pertaining to this representation. The first is the entire case of the plaintiff, that but for, assuming for the time being that this is a representation stroke warranty, because Mr. Thakkar has also cited the case of warranties. So a couple of King's Bench division cases Mr. Thakkar has cited. Now, assuming for the time being that this is some sort of warranty, some sort of representation, this couldn't have been the representation inducing the party to enter into the contract. Because at the time of, even according to the pleading, even taking the pleading to be true and correct, at the time of this representation, the subject contracts had already come into existence. Because the subject contracts were dated 14th of December 2020, and all of this, which has been alleged to be a representation by me, is taking place in the 3rd week of January. That is my first point. So, but for this representation, I wouldn't have embarked upon this transaction, while it might or might not have some relevance insofar as D6, D7 is concerned. That is not for me to comment. It has absolutely no relevance because D11 was being introduced. The respondent number 11 was being introduced as a supplier at a time subsequent upon conclusion of the 5th contract.
Correct.
That is
the case.
So the case of inducement, no, the entire basis, as I have understood, subject to what your lordship feels, the entire basis of the argument is, by this representation, there is an obligation.
Correct. That is the case. See,
that is the case.
Their cases of the plaintiff's case is also there. The main contract with the defendant number 1.
Absolutely.
Defendant number 1 is to supply the materials. Defendant number 1 has introduced 6, 7, 10, 11. That
all
yes,
the manufacturers
he is not having. So they will supply. And his contention is that, and he corroborated with that with regard to the marker, with regard to the seizure, with regard to the visiting of the contract.
Correct.
That is the link they have made.
What I'm seeking to state here is, it is one thing to state that by virtue of a representation, there is a direct obligation and a privity that is created. And from what I have understood from Mr. Thakkar's argument is, what he has averred, what he has sought to contend is slightly more nuanced. What he has also stated is, no, there is no denial that there is a separate agreement insofar as the plaintiff and the defendant number 1 is concerned. But for the warranty, but for the representation by D11 and D12,
Correct.
he would not have embarked upon those transactions.
Correct.
So it is a collateral warranty which creates an independent obligation.
Correct.
That is the argument.
That
is the argument. So now, and to that I'm saying the first part of argument about it being collateral to anything perhaps cannot or does not arise in the instant case, because at the time of the alleged representation, assuming it to be a representation, the subject contract had already come into existence. The obligations of the parties had already been crystallized under the 5th and 7th contract even prior to all of this happening. My second argument is,
so that's why the defendant number 1 has made out a case to avoid the section 45 to arbitration clause. You have made a party to link with the defendant number 1 so that the
absolutely,
arbitration can be.
absolutely,
Case made out by the defendant.
absolutely. I bow down. Now, that is the first case. Now, up to the second issue that your lordship has, a very pertinent question that has fallen from your lordship. Does it render it an independent obligation? Is it capable of it being rendered an independent obligation? In my humble submission, your lordship will kindly see, even if now cases have been cited regarding a warranty by a third party to the contract. That was the precise collateral arrangement that Mr. Thakkar had emphasized upon. A warranty, an independent warranty by a third party to the contract, creating an independent obligation. Now, your lordship will kindly see, taking it to be true and correct, what is the representation? What is the alleged representation? The defendant number 12 requested Mr. Ali to make advance payment so that he could forward it to defendant number 11. On receipt of such advance, defendant number would commence delivery.
That is with regard to arrangement for supply of the materials which the plaintiff requires.
Absolutely. Even taking the terms of this representation, the alleged representation to be true and correct, it, in my humble submission, does not make out a case of an independent promise to perform any future act. Because for it to be a promise, it has to be an unequivocal statement that, look, I will definitely supply. Then I would have understood the applicability of those cases. Taking it to be true and correct, it does not, in my humble submission, make out a case of an independent warranty at all. My third point vis-a-vis this is, a mere bald assertion or allegation would not make out a prima facie case. It has to be supported by some documentary evidence, some corroborating material. My fifth point is, and this is a legal point apropos this, once the rights and obligations of the parties are laid down in a formal, crystallized contractual document, it is not open for a party to expand, distort, or modify the scope of the obligations by introducing any parole.
No, that can be done. That can be done if a principal contract has been entered with A to B, and it is found that that contract cannot be completed because the B or A is not, so the third party is also required.
I bow down.
So by way of, it is not necessary to enter into a third party contract. By way of communication, to conclude the contract, the third party can enter.
Absolutely. Absolutely.
Third party can enter.
Absolutely.
And with the materials and the document, it can be said that you are connected with that contract.
Correct. Absolutely. I bow down.
That is the main what Mr. Bose has also argued.
Absolutely.
The same thing.
Now, to make out an independent case that the delivery obligation is not only that of the defendant number 1, but parallelly, all these defendants, including defendant number 11, also has a separate obligation, is perhaps a different case. Now, this multiplicity, this introduction of a separate independent delivery obligation, apropos a particular contract that stands crystallized today, in my humble submission, the parties cannot go beyond the four corners of that contract in ascertaining rights and obligations to supply. Now, what I mean by that, now if a party has admittedly entered into a formal contract for supply of 1000 metric tons. Can he now, at the stage, at the interim stage, file an application and say, oh, by the way, over and above the obligation of the defendant number 1, some other party was also obliged to supply me in respect of this particular transaction.
That's why unless there is a what we said, the direct contact or indirect by way of any communication.
Absolutely.
Communication
Absolutely.
or by transfer of money.
Something.
Or through even if not, if we prove that suppose today you have transferred A has transferred the 10 lakh rupees in the contact of in the account of the B. And the B on the same day that amount has been given to the C, and the C is transferring with the case made out. Then it can be presumed.
There can be an allegation in that case. There is a back-to-back transaction.
That's right, back-to-back.
Back-to-back transaction.
Correct.
And Mr. Bhattacharya very rightly pointed out, even in the case of a back-to-back obligation and contracts, there are cases, Your Lordship, of contracts with identical terms. First entered into between the final buyer and the exporter, an exporter with a manufacturer, with identical terms, identical markup pricing, etc., which are directly correlated. Even they are independent contracts, Your Lordship. Even in cases where these contracts, we confront these contracts, and in the situations of special damages, they are all treated to be independent contracts, because that does not constitute a direct obligation vis-a-vis the first buyer and the final manufacturer, final buyer and the manufacturer. And Mr. Bhattacharya has very rightly pointed out, I will not labor upon it. There is no privity that, and in this case, it is not even the case of the plaintiff that there is any such back-to-back arrangement. It is merely a case that, oh, by the way, because you are involved at the stage of some commercial negotiation, you now have an independent obligation. Your Lordship will kindly see the distinction between these two circumstances. Simply by becoming privy to some commercial negotiation, it cannot be said, I have undertaken an obligation and I become liable. To ascertain, to impute liability, something more than that is required. As Your Lordship very rightly pointed out, some sort of direct contractual arrangement. Now, it is not their case that there is any direct formal contractual arrangement ever between the plaintiff and the defendant number 11. To the contrary, now, upon this arguments being made, the argument is there is a collateral.
Yes.
Because of the collateral warranty, because of the warranty given by me, there is a collateral obligation. That is a different issue. And to that, I'm saying a collateral contract cannot be implied willy-nilly. For that, one has to look at the nature and character of the warranty.
And that is a point of evidence.
Absolutely. And what he says, and even taking the pleading to be true and correct, the pleading does not undertake a direct obligation. Now, these are the 3-4 points vis-a-vis the defendant number. Now, Your Lordship will kindly note that factually speaking, the 5th contract, if Your Lordship kindly takes page 211 in volume 2.
Yes.
Your Lordship, see, I'm a complete stranger to this. There is no reference even in the 5th contract. Couldn't have been, because I was not in the picture.
Yes.
Couldn't have been. This is the 5th contract, Your Lordship, and by way of an invoice dated 14th of December 2020.
Yes.
Apocalypse, Duarthim. Now, is there any reference? I'm a total stranger to this.
Yes.
And my submission is that the simpliciter alleged representation, A, on the face of it, it does not make out a case of a warranty. It's not a warranty. B, in any event, that cannot impute me with a separate and independent liability. I will distinguish very quickly Mr. Thakkar's cases on this. And the 7th contract is at page 213. So it is an admitted position. insofar as the obligation to supply to plaintiffs are concerned.
Yes.
I have no privity insofar as these contracts are concerned.
Yes.
And my submission is the subsequent representation after almost a month of entering into this contract cannot alter this matrix of obligation between the parties. That is my submission, Your Lordship. Now, Your Lordship will very quickly, I will just, insofar as the aspect that once there is a written contract, because what is the question that arises today for consideration, even if it is at the prima facie stages, does D11, who is obliged to supply to the plaintiff? Does D11 has a separate supply obligation vis-a-vis the plaintiff? Now, my submission to that is that in the face of formal written contracts disclosed and in the face of non-assertion of any other contractual arrangement, the obligations have to be found within the four corners of the contract and contract alone. To that, I was proposing to cite section 91, 92 cases. It might be unnecessary. I will very quickly take Your Lordship. I will not detain Your Lordship very much. This is 1996 4 SCC 551. Just for that principle, that aspect. Because it is nobody's case that there is a formal written contract between D11 and the plaintiff. Now, in these facts, Your Lordship will straight away come to para 7. And although it is a case of section 91, 92 of Evidence Act best 7. Although it is a case of that, it says something more on the principle.
Correct.
And that is what I'm referring to. At the outset, it must be borne in mind that the agreement between the parties was a written agreement and therefore parties are bound by the terms and conditions of the agreement. Once, this is what is relevant, Your Lordship, this is what I'm referring to. Once a contract is reduced to writing by operation of section 91, it is not open to any of the parties to seek to prove the terms of the contract with reference to some oral or other documentary evidence to find out the intention of the parties. Under section 92 of the Evidence Act, where the written instrument appears to contain the whole terms of the contract, it is very important. When the written instrument appears to contain the whole terms of the contract, then parties to the contract are not entitled to lead any oral evidence to ascertain the terms of the contract. It is only when the written contract does not contain the whole agreement between the parties and there is any ambiguity, then oral evidence is permissible to prove the other conditions, which also must not be inconsistent with the written contract. Now, the immediate repartee to that would be that we are not talking about modification of D1's obligation. So how is this case relevant?
So that's why I'm telling, if there is no evidence and they are harping upon the negotiation with the third party, who's the third party?
That
Mr.
I'm saying.
Mr. Ali was there, of representative of the plaintiff, and the plant or factory was inspected, and wherein you stated that. So that is not the contract
at all.
Terms of the contract.
Correct.
So that is to be decided during the trial how far the plaintiff will prove the case by way of oral agreement. By way of oral, because it has to be, it is not, that's why the written terms, you cannot deny it automatically if the parties sign. If there is no terms in the agreement, if you relied upon something or you denying something, then you have to adduce the evidence.
I bow down. The distinction I'm seeking to draw is, Your Lordship, this. In the entire plaint, the basis of the reliefs are firmly founded in the formal contracts.
Correct.
Firmly founded only in the formal contract. They cannot have a prevaricating stand regarding
Nothing.
that. There is no allegation that this is not the entirety of the matrix of the understanding between the parties. In that context, can this representation at all be independently understood to be a separate and independent obligation? Even taking the terms to be true and correct, it cannot. That is all.
It is not, it is independent. They are also not, it is not the case, they are independent. Their case is also that with regard to the
obligation of the defendant number 1 to the plaintiff.
Correct.
I bow down, Your Lordship. Now, to that, perhaps this becomes relevant, because what one is seeking to try here is to modify the matrix of obligation under the original contract. That is my submission.
Okay.
To that, I will not duplicate this judgment. There is an old judgment as well. I will refer to it in the written notes. I am not. Now, insofar as the second legal aspect is the upshot, the sequitur of all this argument, the second legal aspect is, and I will also tie up, in absence of a jural nexus, any kind of jural nexus, I'm not party. I have shown your lordship the nature of the representation. This nature of the representation itself does not constitute a promise of any nature. Thirdly, it is not backed by any corroborating material. Now, in absence of a jural nexus, a party is not even a proper party, much less a necessary party against whom any relief can be claimed.
Yes.
If no reliefs can be claimed against me, since there is no jural nexus, the question of establishing any prima facie case as against me for grant of any interim relief in aid of the final relief cannot and does not arise.
Yes.
And to this, your lordship, I have cited this case one too many times before your lordship, Ramesh Hirachand Kundanmal versus Municipal Corporation of Greater Bombay. Just para 10 and 14, I will just once again very quickly refer to. Huh? Partition 1992 to SCC 524. Paragraphs 10 and 14.
Yes.
6 is just the issue. Your lordship recalls in Order 1, Rule 10, Sub-Rule 2, the word necessary is used to define proper party. That age-old confusion. So this court embarks upon assessing what is the definition of proper party, because the words used in Order 1, Rule 10.2 is a party whose presence is necessary. He is a proper party. So to that, the court makes that distinction of legal interest, commercial interest, this Razia Begum cases, etc. And finally holds at para 14, there has to be a direct legal interest. May I read? It cannot be said that the main object of the rule is to prevent multiplicity of actions, though it may incidentally have that effect. This is Order 1, Rule 10. But that appears to be the desirable consequence of the rule rather than its main objective. The person to be joined must be one whose presence is necessary as a party. This is in the context of definition of proper party. What makes a person necessary party is not merely that he has relevant evidence to give to some of the questions involved. That would only make him necessary witness. The classic enunciation. It is not merely that he has an interest in the correct solution of some questions involved and he has thought of relevant arguments to advance. The only reason which makes it necessary to make a person party to action is so that he should be bound by the result of the action.
Correct.
And the question to be settled, therefore, must be a question in the action which cannot be effectually and completely settled unless he is a party. Now, can a decree be pressed for against me under the main contract? In my humble submission, no. In the next sentence, the line has been drawn on a wider construction of the rule between the direct interest or legal interest and commercial interest. It is therefore necessary that a person must be directly or legally interested in the action, in the answer. He can say that the litigation may lead to a result which will affect him legally, that is by curtailing his legal rights. The test is, may the order, the quoted part of Justice Devlin, the test is, may the order for which the plaintiff is asking directly affect the intervener in the enjoyment of his legal rights. So it's a case of direct legal interest and jural nexus. Without a jural nexus,
yes,
something can be asked against me. Now, on the conspectus of the facts, my question is, can this prayer at all be made against me in law? If not, Just by crafty drafting, pleading, I cannot be rendered a party to the proceeding, because it is my submission that no jural nexus of whatsoever nature has been established by the plaintiff vis-a-vis the defendant number 11.
Yes.
And the only jural nexus, alleged jural nexus, that has been sought to be averred is that of a case of a collateral contract by reason of a warranty. And this is where I will stop by just distinguishing Mr. Thakkar's case very quickly. Now, the first case Mr. Thakkar has cited, that is the proverbial connecting point, that there is a jural nexus because there is a collateral contract by way of a warranty. Very high threshold, but
yes.
The first case, Shanklin Pierre versus Detail Products, 1951 to King's Bench 170, is the proposition whether a third party to the contract can furnish an enforceable warranty. That's the proposition.
Yes.
So that the bench says that there is no reason why there can't be an enforceable warranty by a third party to the contract. And very importantly, your lordship will know, third party to the contract is emphasized because there is no allegation of a formal contract between D11 and plaintiff. So this case holds that no, a third party to the contract can give a warranty. Now your lordship will see what is the nature of the warranty. It's a very, your lordship has found the decision. I'm sorry.
What is citation?
1951 to King's Bench 170. What was found it?
Yes. Shanklin.
Shanklin Pierre.
Yes.
Sale of goods, express warranty. Warranty given by seller to plaintiff, consideration will cause the buyer to buy. Action. It's a very short decision, your lordship. I'll just read the facts once very quickly. The plaintiffs were the owners of Pierre at Shanklin in the Isle of Wight, which during the war was partly demolished and allowed to fall into disrepair. On July 22, 1946, they entered into a contract with contractors to have the necessary repairs effected and to have the whole pier repainted with 2 coats of bitumastic or bituminous paint. Under the contract, the plaintiffs had, however, the right to vary the specification. On July 22, 1946, the South Coast director of the defendant company, as a result of an inquiry by the plaintiffs, went to Shanklin with the object of obtaining the company of the contract for the repairing of the materials. He there saw the managing director of the plaintiff company and later also the plaintiff's architect, and told them that certain paint manufactured by the defendants and known as DMU would be suitable for the work. He showed a pamphlet to the architect which stated that the 2 coats of DMU applied to the clean metal surface would keep the underwater surface, topsides and the wind and water line of the ship free from corrosion for over 4 years. He told the architect that the paint was not subject to creep, suggested 2 coats would be used on the pier as protective coat, and promised that it should have the life of at least 7 to 10 years. So there is a clear promise as to a future state of affairs.
Yes.
That look, if you use my paint, it will at least have a life of 7 years. It will prevent corrosion in such and such manner. On the faith of those statements, the plaintiff caused the specification in the contract and the contractors to be amended by substitution of 2 coats of DMU. So a unequivocal promise as to a future state of events, and upon reliance of that, he modified the formal contract with him and the contractor. Now the question arose, will DMU be liable for this warranty that it had made? That was the question. Now in the facts of this case, there was no promise as to a future state of affairs. I merely had stated, if you pay him advance, if he forwards me the money, I will give him the material. Did I not? I did in my humble submission, and I'll show my reply on that. And in reliance on that, there is no change of position to the detriment.
Correct.
Which is the case here.
Correct.
And because it is in the nature of a warranty to be enforceable against a third party, it is a genus of a estoppel. It's a promissory, because there has to be a promise. And upon reliance of my promise, somebody changed his position. That's why it's enforceable. Now, this entire case cannot have any application with deepest of respect to the facts of this case, because A, I did not make any unequivocal promise as to a future state of affairs, and B, there is no reliance upon that and change of position. So where is the question of enforcement of a separate independent obligation?
Yes.
Now, the next case, which Mr. Thakkar has cited, 65 2 QB Queen's Bench. This was 51 2 KB 874, Your Lordship. 854.
Earlier one.
Yes. It was 854. And 65 2 Queen's Bench 178.
Sorry. Yes.
Now, in this case also, Your Lordship, we'll see the nature. A specific promise was made in respect of the specification of the goods.
Correct.
By the final manufacturer.
Yes.
Now, is it anybody's case that I made a promise as to specification of my goods, which later were found out to be incorrect? That is not the case. If I may just quickly read. The defendant sand merchants warranted to the plaintiff, chrysanthemum growers, that BW sand supplied by them would conform to certain analysis. And the transaction ultimately was entered into through a third party.
Correct.
Akin to the defendant number 1 in the instant case.
Yes.
And in that context, the court said, no, you are the manufacturer. You warranted a specification. On that basis, he agreed to obtain the goods. So, of course, there is an independent collateral obligation insofar as you are concerned. Now, this case is distinguishable on 2 counts. A, relying upon my representation, he did not enter into the contract. That is point A. Point 2 is, I did not make any promise as to specification which was found to be untrue. That is not their pleaded case. That is not their argued case. And thirdly, as I have stated for the previous case, neither have I made any promise of any nature. That is all. And just to give the reference from my opposition, Your Lordship, my affidavit in opposition, I have given, if Your Lordship kindly takes, and I will point this out just for fairness. I had said that, look, whatever money has been paid to me, apropos the purchase order. The purchase order is at page 31.
Yes.
The purchase order placed by the defendant number 1 on me for 1500 metric tons.
Yes.
Apropos the purchase order and apropos the rate specified in purchase order, whatever money has been given to me, I have effected supply of that quantity.
That is with regard to D1.
Absolutely.
Because it is not, that's why it is not that you are directly supplied to the
Never. Because even my contractual document vis-a-vis D1 is at page 31, Your Lordship. And apropos this, they had paid me around 5.96 crore rupees, which corresponds to 810 metric tons price as per the agreed rate. And I have furnished my bank account to show that the payment is 5.96. I have furnished the sales register to show that I have supplied the goods. There is no dispute, no demo whatsoever by the defendant number 1 that I have not supplied 810 metric tons. And I have also furnished GST invoices. Those are at page 32 onwards.
Yes.
And Your Lordship, and I must point out for fairness, they had filed a supplementary affidavit saying that, very well, you have furnished GST invoices. So GST invoices are mandatorily registrable. So it must be registered. But here are 3 screenshots, which shows that this IRN is unregistered. A supplementary affidavit was served on us. I don't know if they have formally filed it or not.
Supplementary file हुआ है?
And I'm just proposing to deal with this because I was served with it. A point should not be later taken that I did not point it out. Has it been served? Has it been filed? तो मैं file करूँ?
हम भी फाइल कर रहे हैं लीव है क्या फिर लीव इज ग्रांटेड no leave is granted
Because factual assertions is made, I should be able to deal with it. That's why I invited
we
you.
had used supplementary affidavits for defendant number 6 as well as 10.
11.
Supplementary affidavits 6 and 7 that is
That time Mr. Bose was arguing, so my lord, we had relied upon that.
no whether this was served to Mr. Bose.
Yes.
Mr. Bose has not argued on this. Where is the service?
And there is a similar supplementary insofar as D11 and 12 are concerned. That's why I invited your lordship's attention to that. Because I should be able to deal with it. They have made an allegation.
If you are filing like this application, I am vacating the interim order. I will not extend the interim order. Whatever application, whatever the document you want to file, you file. I will hear days together. This is not the way. One advocate started hearing and you are coming with an all applications.
No, my lord.
Sorry, I am vacating the order.
My lord, we have not filed any application.
So why you are filing all this?
My lord, this was
Record or not, I am vacating the order.
kindly do, very well, my lord, we shall not rely upon this. Because my lord, we have served them long back.
Maybe served. Then you are every time you are extending the time, the argument is not going to be completed. Every hearing you are filing one or the other supplementary affidavits. This is not the way to conduct the hearing of the interim application.
My lord, only may I indicate one thing, my lord, subject to what falls from your lordship. My lord, when Mr. Bose was arguing, my lord, at that point of time when we had filed
I will not take any supplementary. If you are ready to argue, then I will clear the I will complete the argument of the parties. Then I will fix the matter for our order. Otherwise, if you want to rely upon the document, so okay, come with the document. I will invite you, but I will vacate the interim order.
Defendant number 6 had already relied upon this supplementary affidavit because we had filed it long back. Not filed, we served it long back.
Where is
D6 also filed. But because D10 is the defendant number 11 and 12 is arguing.
where is the supplementary reply to the supplementary affidavit of the D6?
No, ota to
It's filed by the plaintiff.
this 11 and 12. Yes, plaintiff supplementary.
Yes, plaintiff.
They are not relying upon it, then I will not make any submission regarding that. Then I'm resting my case on.
This is the supplementary affidavit to the affidavit in reply to the defendant.
Correct.
Number 6.
When it was filed, when it was served. Who is appearing from 6 and 7?
6 and 7.
Have you received this? Correct. That because it is not.
Yes, it's there. This is the one.
29 file, it is taken on record. So the 29th order. Because Mr. Bose has not dealt with this document.
They are saying that transaction.
January.
ওখানে রয়েছে তো
চিঠি দেখিয়েছিলাম তো for inspection of the
Now, your lordship would kindly recollect, we had placed that advocate's communication for notice to produce.
That
on
is
which
dif-
there was an argument, but that is possible.
That is different
The
thing.
supplementary affidavit.
That is
We had
different
traced
thing.
from
That
that.
Mr. Thakkar
Thakkar
has
was
argued, he has,
but-
you have given the
We
notice
had
to,
documents from the supplementary affidavit.
it is not on record.
Last document.
The
Correct.
draft annexed to the supplementary.
Cannot be dealt with because
It
was
is
never
not, it
formally
is not
filed.
taken on record. You have filed your, my officer has taken on 27th, but it is not in record. And Mr. Bose has not dealt with, because all argument is with me. The written notes are with me. I will not allow this.
Government, so we have to factually
I will not allow all these things. If you want to rely upon, I will take on this. I will vacate the order of the interim. Then you, whatever the document you want to file, you file it. I will hear. Yes, together.
No, but then we
This is
should
not the way.
I understand, but
Every time you going to the mail and getting one paper and coming with the supplementary affidavit, which you are not disclosed in the application of interim application.
this is in response to their affidavit.
Whatever it may be, supplementary, how the supplementary will come? You got the opportunity to file the reply, you file the reply. You given the notice, Mr. Thakkar has argued the matter 2 days with regard to the notice to supply the document. They are not supplied. I take a note of it. Then Mr. Bose has given the reply. Why you are not supplied to that? That I have taken that. This I am first time I came to know
Then
that
you-
Mr. Banerjee has argued. Otherwise, I could not have been.
Then I shall take back the supplementary.
Yes.
Then those are my submissions, Your Lordship. I'll file my written notes by Monday, Your Lordship. I will file my written notes, Your Lordships, by Monday.
Okay. Yes, any other person?
I extended my time by about 20 minutes, Your Lordship, but I had promised I'll finish.
It's okay. Yes.
Number 13 and 14, Your Lordship.
Hmm.
I'm led by Mr. Tonoy Chakraborty in this matter. He's in some difficulty. He couldn't come to court today. But the thing is that we have already filed GA 11 of 2025 for vacating of the interim order, Your Lordship. May I file the notice of motion and the affidavit of service to that effect? And we have also served upon them.
One submission, defendant numbers 13 and 14, I filed the application. That was served 2 days back, possibly.
That I will see.
So, my lord, I would be seeking an affidavit.
P6, 11 and 12, I think.
Yes.
Oh.
11 and 12. I'm deeply fresh. I'll take Your Lordship.
Okay. No, what up?
Actually, 3 volumes are there, Your
Hmm.
Lordship.
Have you,
And,
when you served?
We have served on 29th, Your Lordship.
29th of?
No, no, Your Lordship. 30th. 30th.
Give.
Day before yesterday.
Yes. 30th.
30th of April?
April.
You have not filed the affidavit in opposition.
No, Your Lordship.
Okay, I will take this separately. You have not filed the affidavit in opposition. I will relinquish your right to file the affidavit in opposition. 6 months the case is going on. Yes, on anybody or? When you give the reply?
1, 2, and 3 and 5. They're filing my notes of argument.
Your Lordship, notes.
I will that I will dealt along subsequently.
Your-
If you have not filed the affidavit in opposition, I will dealt separately. Let me dispose of the interim application first.
Your Lordship,
This is not the way.
regarding the defendants 13 and 14, we have prepared
Yes.
notes of argument, Your Lordship. We have also prepared a note.
Give the written notes of argument, but I will record chance to file the affidavit in opposition with regard to the J1 is closed, who has not filed till date.
Your Lordship, we have already stated the reasons for which some of the reasons were documents and all the
Whatever,
those were
6 months. One person is obtained the interim order, other person is suffering, and you are searching out the document. Record.
Lordship. May I file the written notes of argument?
Yes.
13 and 14, Your Lordship.
Concession suffering for the plaintiff. Concession suffering for the defendant 1, 2, and 3, 1, 2, 3, and 5. Concession suffering for the 6 and 7. Concession suffering. Who is for the 8 and 9? Yes. What is your submission?
File my written notes about
Give. So suffering for the 8 and 9, so suffering for the 10, so suffering for the 11 and 12, and so suffering for the different number 13 and 14. Full stop. Counsel for the defendant number 6, 7. Who has filed the return? You. Defendant number 1.
Yes.
Defendant number 1, 3. 1, 2, 5 and 7.
1, 2,
Defendant number 1, 2, 5, 1, 2, 3, 5. 1, 2, 3 and 5, comma, defendant number 6 and 7. And who filed the return notes today?
Your Worship, defendants number 13 and 14.
Defendant number 13 and 14. And anybody has filed?
I'm filing it on Monday.
Have filed their return notes of argument. Let the same be kept with the record. Counsel for the defendant number 11, 10 and 11, 10, comma, 11 and 12 have concluded their argument. Full stop. Anybody will argue on further?
We are
No.
adopting the submissions with regard to submissions made by defendants number 6 to 12, Your Lordship.
Okay. Counsel for the defendant, other defendant submit that they adopted the submission made by the counsel for the defendant number 6, 7, 10, 11 and 12. Full stop. Who has not filed the return affidavit in opposition?
Defendants number 13 and 14, your 13 and 14 have
8
not
and
filed.
9, 13 and
and-
14.
Defendant number 8, 9, 13 and 14 who not filed their affidavit in opposition. Chance to file the affidavit in opposition is closed.
Your Lordship, one humble submission, if I may make, before Your Lordship, with Your Lordship's leave. In the very inception, when the matter was called on, Your Lordship, Mr. Gupta made a humble made a submission with Your Lordship that if this may be treated as the affidavit in opposition, then they will go for a reply.
You
And all.
give the undertaking that you will not argue further on the basis of this this application which you filed. You give submit. I will record then your submission. You will not argue with regard to the vacating the order what you submitted.
If Your Lordship gives us leave, we can argue. We can argue on the point.
That's why if you want to argue, I will take that application separately.
Your Lordship,
I am not disposing of your application.
Your Lordship can grant us that leave. We will come back with Your Lordship and argue our.
That will I will submit. When you will argue? When you reply?
Any day barring, next week, any day barring the 16th, 16th.
Counsel for the plaintiff press for time to give reply to the argument made by the defendant number 10, 11 and 12. With regard to 6 and 7 is over.
Yes.
10, 11, 12. Let the matter be appear on
Except 8, 9, 13th and 16th. Oh.
9, 10 can be
9,
fixed as
12 holidays, yes.
specifically fixed matter.
9, 12. But 14, 15, 16, 14, 15.
कोई डेट है देखो उसमें 14, 15, 16 कुछ है
15, not 15.
कौन सा मंडे कितना बजे
Bishop, on 15th, we are in some difficulty. Your
No,
Lordship.
he is not arguing.
no reply
Or are you?
15th May 2025 at 11:30 only with regard to reply by the plaintiff to the submission made by the counsel for the defendant number 10, 11 and 12.
D10, 11, 12.
Your Lordship,
But the interim order be extended.
Your Lordship, defendants number 13 and 14 also wish to press their application. If Your Lordship,
So the defendant number
13 and 14.
13 and 14 have filed an application being GA number
11 of 2025.
11 of 20
So,
11 of 2025 praying for vacating the interim order. Counsel for the plaintiff press for filed affidavit in opposition. Let affidavit in opposition filed within 3 weeks. Reply if any to be filed within 2 weeks thereafter. 2 weeks thereafter. Let GA 11 of 2025 be fixed for hearing on 26th of June 2025.
Could a similar order
Counsel
be
for
asked
the
for also 8 and 9? Because they have also filed a vacating.
8 and 9.
8 and 9 is also, that is J number 12.
8 and 9.
J 12,
8,
identical
9,
order may be passed.
8, 9, 11, 12.
8, 9, 13, 14.
13, 14. 8, 9, 13, 14. Same order. But see the number, uska 8, 9 का number क्या है? J12.
J12.
11 and 12. Okay. Counsel for the plaintiff submit that the interim order going to be expired today
On 8th.
due to expired on 8th of May 2025 and placed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order which is due to expire on 8th of May 2025 is extended till 11th of June 2025 or until further order whichever is earlier. The defendant number 10, 11 and 12 are at liberty to file the written notes of argument by 6th of May 2025.
Great. My lord, I sincerely apologize.
Yes.
Gratefully, Your Lordship.
Nine, Your Lordship, I am appearing on behalf of the plaintiff. Lordship, we have settled in
Appearing on
terms of,
behalf of defendants 2 to 4, Lordship.
terms of an agreement dated 20th March 2025.
Lordship, for small indulgence.
Yes.
Lordship, GA2, which is running in the list, which is our application for Order 7, Rule 11. Lordship, kindly take.
So you want to press that application? You want to press application Order 7 Rule 11? Yes, what is your submission?
Kindly, if it is not dismissing, then kindly fix a date for.
No, the matter is going to be
And
settled.
dismissed.
It is settled or not?
Yes,
You are also the party.
Yes.
Yes,
Your
yes.
defendant number?
1.
1. How many defendants?
4 defendants, Lordship. I appear for defendants.
Your
2 to 4.
Karnataka Bank.
Yes.
And this agreement was entered between
This agreement is entered between defendant number
plaintiff and the defendant number Saroj.
2 to 4. 2 to 4, Lordship, and the plaintiffs.
Saroj Devi. Rathi.
And coastal packages.
Yes. No, this is entered between defendant number 2 and the plaintiff, Lordship.
And 3 and 4 are the directors of defendant number 2.
Directors. Lordship, the defendant number bank has also issued an NOC. Lordship, I'm also handing over. This is also even dated 20th March 2025.
But this agreement was entered by you in person. It is not an individual. Kindly see the agreement, madam.
My
This settlement agreement.
yes.
The second Saroj Devi Rathi, an individual and a wife of so not the company.
No, Saroj Devi is the plaintiff, Lordship.
Plaintiff
is
okay,
an individual.
Plaintiff is an individual.
Yes,
Acha,
Lordship.
Saroj Devi is you have made
Yes, the parties have
opposite.
Yes, yeah, Lordship.
Postal Packages and Private Limited.
So Lordship would kindly record that in terms of that agreement, and Karnataka Bank has also issued a no objection. They have handed over
All the necessary
legal
documents. Yes, Lord.
So and so appearing for the plaintiff. So and so appearing for the defendants. So what you want? This agreement, but if you want this agreement decrease to be drawn, then it is to be filed in original.
Yes.
And there is no signature of the witnesses. Or only want only on the basis of your submission, and the basis of this I will dismiss settlement, then I will record and I will dismiss the matter has been settled between the as per your submission. What if you want the decrease to be drawn, then the original agreement has to be placed on record.
Lordship,
That will be made a part of the decree.
Yes, Lordship, the original is not with me. Then Lordship would keep it on Monday.
Again.
Lordship, actually,
Dismissed.
no. So if it is if it is in the interest of the party, then I will make that same prayer on Monday. The original is not with me.
And there is no signature of witnesses.
Yes, Lordship. So maybe
It is not also notarized, not affirmed. How the agreement?
basis this, the action has been taken, and performance is
What
complete.
you
Praise of the suit are infructuous now. The praise of the
That's why I'm telling. If it infractuous, dismiss as
yes,
infractuous.
dismiss.
I will say that.
Yes, man.
In
Or if-
terms
None
of
of the
this
praise,
agreement,
none of the praise survive.
Correct.
right? But in
So
terms
and
of this
so for the
agreement, if
plaintiff,
your
so and so
lordship would
for
kindly
the
record that
defendant
much.
number 1 and so appearing for the defendant number 224. 224. Counsel for the plaintiff has handed over a copy of the settlement agreement entered between the defendants number 224 and the plaintiff dated 20th March 2025, wherein the dispute between the plaintiff and the defendants number 224 have been settled. On the basis of the settlement entered between the plaintiff and the defendant number 224, comma, the defendant number 1 bank, namely Karnataka Bank Limited, had also issued a letter dated 20th March 2025, confirming that no dues in respect of the property in question and for releasing of the document deposited by the defendant number 1 company. That is the title deed dated 21st of July 2016, which is being handed over as per the board resolution dated 20th March 2020.
I'm also handing over the board resolution. This is also the certiorari.
What is this?
This is
Full
the
stop.
board
The
resolution.
counsel for the plaintiff has also handed over the board resolution dated 20th March 2025. The counsel for the respective parties submit that as the parties have settled their dispute and nothing remains in the suit to decide further, accordingly, this court find that the suit filed by the plaintiff has become infructuous due to settlement between the parties. Accordingly, CS Comp 806 of 2024 is dismissed as infructuous. Full stop. The communication, the copy of the settlement agreement, comma, communication dated 20th March 2025, comma, resolution dated 20 March 2025 be kept with the record. Consequently, all connected applications are also dismissed. Interim order, if any, stand vacated.
Lordship, there's one thing I need to point out. This agreement is entered into between the plaintiff and the defendant number 2. Lordship possibly has recorded 224.
Defendant number 2, defendant number 2 company.
3 and 4 are the directors of defendant.
2 company,
Proper to say.
company, and the defendant number 3
Three
and
and
4
four
are the directors of
Correct.
the defendant number 2 companies. Okay.
Obliged.
Much obliged.
Next.
Lordship has also taken note of the other application that my learned friend just pointed out, that is pending.
All application
All applications.
All application is dismissed as infringement.
Lordship.
All connected application, your application includes in that. उसमें करना मैडम ऑल एप्लीकेशंस वाला ना बिंग जीए नंबर दे दीजिएगा. Next item.
No, I'm appearing for the plaintiff, Lordship. There is
Yes.
one application filed by the plaintiff and 2 by the defendant, Lordship.
GA4, GA5, GA6.
Yes, my lord.
Yes, what are the applications?
No,
Who is for the
GA6
plaintiff?
It's my application.
GA4 is mine. It is my application, my lord.
For the plaintiff, you are for the.
I'm for the plaintiff.
You are for the plaintiff.
Yes, my lord.
What is the GA4?
GA4, my lord, I have a dual prayer, my lord. A prayer for closing their right to file evidence. Alternatively, my lord, they may be allowed to file their evidence and a commissioner be appointed. On the last occasion, my lord, we had agreed, my lord, that we will concede to their applications and they will also concede to filing their evidence and a commissioner will be appointed, my lord. My lord, I believe, my lord,
So what will happen to your application?
My lord, we will withdraw it. My lord. Yes, my lord. If the commissioner is appointed and my lord, they had to file, my lord, if it is imperative to
Now,
inform
what
your
is the
lordship.
stage of the suit?
My lord, my plaintiff has been examined in full, my lord. We have only one plaintiff.
On commission?
Yes, my lord, on commission. My lord, lordship's order was also
filed.
Yes, my lord. Commission report has been filed on 17th of September 2024, my lord. The report was filed and direction was passed on them to file their evidence. My lord, they've not
You have
been
not
able
filed the affidavit of evidence.
It's ready.
Now it's ready, my lord. And they have also filed an application for bringing on record additional documents.
So what is the GFCOM 5?
My lord, that is my application, my lord, for disclosure of additional documents. And my lord, GS6 is another application of mine. That's the demurrer application, Order 7, Rule 11.
So what do you want now?
My lord, the arrangement, as my learned friend has pointed out.
Correct. Because if this court will appoint the commissioner to
Lordship.
allow you to examine the witness on commission by filing, I will fix the date for whatever it may be. So
Lordship.
their GF4 will become infractuous. It will be disposed of. And what about now in the demurrer application? What will happen?
My lord, this was the arrangement that the preliminary issue will be framed, your lordship, and that will be heard first. Vis-a-vis this Order 7, Rule 11 application.
Is there any order?
My lord,
No,
that
my
was
lord.
the arrangement, your lordship. Mr.
Arrangement
Jishnu
between who?
Chaudhary was appearing.
My lord, we had made these submissions, my lord, before the Honorable Justice Shugato Mojumdar, my lord, but thereafter the matter has now come before your lordship. So therefore, my lord, these matters were, the applications were not
What
heard.
is the demurrer?
Your lordship, our contention is that we are the agent
Hmm.
of the principal and therefore it is barred. My lord, suit doesn't lie against the agent, your lordship, the defendant. So, my lord, on that account, your lordship.
I will pass an order with regard to your demurrer application will be taken
My
up
lord,
for hearing at the time of final argument by
yes. And my
framing
lord,
an additional issue on the
my lord, in
basis of
any event, this issue is
That
there.
was the understanding, your lordship,
Ah.
that this will be heard first, your lordship. A preliminary
see,
issue will be framed, your lordship, and that will be heard first.
See, madam, preliminary issue can be framed with regard to hearing of the preliminary issue at first. Preliminary issue or the total issue that has to be decided in the evidence only.
Yes.
Yes, your
Correct.
lordship. I'm not
In the
objecting to
that's
that.
right, in the evidence only.
Lordship.
If you lead the evidence, because plaintiff evidence is closed, now
Lordship.
you want to adduce the evidence, and you have also filed an application, demurrer application. So if this court will say that the demurrer application be kept pending, and what the issue raised in the demurrer application, that will be one issue at the time, because evidence you will lead. Correct. And you already cross-examine on that point, might be.
Lordship.
So I will, if the issue is not there, I will fix the issue, and at the time of final hearing of the total.
That issue may be decided first, your lordship. That is
How
my
it can
only
be decided first?
My lord, that issue is already there, my lord. My lord, the first issue,
that's
whether
a
the suit
blanket
is
issue, your
maintainable.
lordship.
My lord, there,
That's a blanket issue, your
their
lordship.
Okay, no
contention
problem.
squarely
No
falls
problem.
into it.
I will frame the issue on basis of your application, but
Lordship.
that will be decided together. So if it
One and two.
Lord, why I say so, your lordship? Because your lordship, if this issue is decided in my favor, your lordship, then the rest, your lordship.
Okay, I will hear all the issue, but at the time of deciding, I will decide the first issue.
Well, my lord, may I say something humbly, your lordship? My lord, I am led by Mr. Thakkar, your lordship. My lord, may kindly fix this matter on Monday. May I come back?
Problem, madam.
There
When
is
the
no
matter is
requirement.
taken, the senior is not coming. Then when the court has started putting the question, then the senior is not there. Senior is out of station. That is the problem. The simple, see, you think the practical.
Lordship.
No problem. I am telling you. I think your senior will also not be denied. Will be the issue? No problem. If you maintain it, I will hear the matter in total, but I will take the issue first. First issue is decided in your favor against the plaintiff. Automatically, the court will not decide any other
Issue number 1 and 2
problem
is
with
my
that,
lord, what they want to press. Whether
No,
the
no, my
suit
lord.
is maintainable as against a commissioning agent.
At first means,
Yes, my lord.
because once the issue is framed, it is not the case that without the issue it has to be decided.
Lordship.
The issue is to be framed. When the issue is to be framed, the issue is to be decided during the evidence only.
Lordship.
Correct.
If
Once
my
the-
lord decides the issue, your lordship frames the issue, your lordship, I do not have any objection to that.
And what about the 6? What is the 6?
My lord, 6 is their application, my lord.
My application for disclosure of additional documents.
My lord, we have no objection to the my lord, but
Commercial suit.
my lord, it's a commercial suit subject to inspection, lordship. If they can provide me with, my lord, that is why, my lord, we had conceded on objection, my lord. We can show these documents are already on record. They still want to bring it on record. But the understanding, my lord, between the parties was we will not press our application for closing their evidence, and we will allow their application for additional documents subject to inspection. But I am honoring this arrangement between the parties.
Where is the GS6? Get the GS6.
Let 6, my lord, is possibly the order 7. 5, 5 is for
is the
addition of documents, lordship.
J6 is the demerer.
Lordship.
My lord, the notice of motion in one of them, my lord, is wrongly kept.
A5 is
GA5 is, my lord, the disclosure of additional documents, your lordship. My lord,
granted different file compilation of the document being annexed.
agreeing to addition.
When the suit was initially filed in the commercial division itself,
Yes, my lord.
and this is a bank statements. You want to rely this bank
Yes, my lord, this is already there, my lord, in the judge's
may,
brief of
may I
documents.
just say this to your lordship, my lord? This is already there, but the Xerox copy is there, your lordship. The certified Xerox copy was not there. So, my lord, we have disclosed that only.
And now there are a few
the
letters.
written statement you didn't disclose this.
Lordship?
In the written statement, you disclose the document.
Yes, your lordship.
The part of judge's brief.
Yes.
No, not just written.
Written
Now the
statement.
commercial case has changed its scenario.
Disclosed.
The written statement.
It is
I think it is disclosed. And my lord, one thing may I just point out to you, lordship, my lord, the plaintiff has also, my lord, disclosed certain documents after initiation of the evidence, your lordship, the trial.
that
we have
was
also,
allowed.
We have also not
And I'm not raising any objection
any
because of
objection
that.
to that.
Look, that is why we agreed to this arrangement.
Yes.
We want to proceed with the suit, lordship.
Sense appearing for the plaintiff, sense appearing for the defendant. The plaintiff has filed an application being GA4 of 2025.
5 minutes.
Praying for closing of the evidence of the defendant, or in the alternative, for issuance of a writ of commission for appointment of an advocate commissioner for recording the evidence of the defendant. Full stop. The plaintiff has the defendant has filed an application being GA5 of 2025, praying for allowing the defendant to bring some additional document on record. The defendant has also filed an application being GA-Com6 of 2025, praying for dismissal of rejection of the plaint. Praying for rejection of plaint. Full stop. It is submitted by the learned counsel for the respective parties that the plaintiff will have no objection if this court appoint a advocate commissioner for examination of the defendant witness on commission. Full stop. The counsel for the plaintiff also not raise any objection for allowing the defendant to disclose the additional documents.
Subject to inspection, my lord.
Additional document subject to inspection of the said document. Full stop. The counsel for the plaintiff submit that the defendant has filed the present filed an application being GA-Com6 of 2025 for rejection of the plaint on the ground that the suit filed by the plaintiff is not maintainable. Full stop. The counsel for the plaintiff submit that the application filed by the defendant being GS6 of 2025 can be taken up for counsel for the plaintiff submitted. The plaintiff has already adduced the evidence and the defendant has cross-examine the plaintiff witness, and now the case is at the stage of evidence of the defendant witness. And as such, the application filed by the defendant being GS Com 6 of 2025 be taken up for hearing at the time of final argument. If necessary, one additional issue can be framed with regard to the issue raised by the defendant in the said application. Full stop. Considering the submission made by the counsel for the respective parties, GA Com 5 of 2025 filed by the defendant is allowed by considering the submission made by the counsel for the respective parties, the defendant is allowed to disclose the document as mentioned in which paragraph? As mentioned in paragraph
9, 11, and
no paragraph
15.
Paragraph 6 A, B, and A, B, C, D.
Yes, my lord. 6 A, B, C, D.
6 A to D.
A to D.
That are the document. 6 A to D.
Yes, gotcha.
As mentioned in paragraph 6, within bracket small a to small d, which are marked as exhibit, which are marked as annexer B to the annexer B to the B to the said application. Full stop. The plaintiff is the defendant is directed to disclose the said document and disclose the original document to the plaintiff for inspection within a period of 2 weeks.
2 weeks. Gotcha.
Within a period of 2 weeks. Full stop. On disclosure of the original document by the defendant to the plaintiff shall complete the the inspection of the document within period of 2 weeks thereafter. Full stop. On completion of the inspection of the additional document disclosed by the defendant, the defendant and the plaintiff has liberty to file the affidavit of admission and denial of document within a week thereafter. Full stop. In view of the above, GA Com 5 of 2025 is disposed of. As regard GA 6 Com 5 of 6 of 2025, this court is of the view the said application be kept with the record and will be taken up for hearing at the time of final hearing of the suit on completion of evidence of the parties, and if required, additional issue will be framed in terms of the said will be issued in terms of the said application, and if the issue is with regard to the maintainability, the same will be decided as issue number 1 before deciding the other issues. Full stop. As regard GACOM 3.
4, my lord.
GACOM 4 of 2025 filed by the plaintiff is disposed of by appointing. Who was the earlier advocate?
Ruchishmita Ghosh, my lord. My
She
lord,
will
we
complete.
are. Do you want? My lord, they don't.
You don't want that.
Junior. As your lordship pleases.
But from the bar, my lord,
Huh?
she doesn't have the time, my lord. That's
She doesn't have a time.
a
So
junior member of the bar may be appointed, my lord, with less fee, my lord.
I am appointing junior member of the bar every time also it is coming to this court clarification. That is the problem. Yes. You can do. You are not a busy man.
No, she's never busy for the court.
So is appointed as advocate commissioner for recording the evidence of the defendant's witness on commission. Full stop. The advocate, the advocate commissioner, the commissioner is directed to inform the examination of the defendant's witness on commission to the assistant registrar of the court in advance, so as to enable the officials of this court to produce the document before the commissioner at the time of examination of the defendant's witness on commission. The remuneration of the Commissioner is fixed at rupees 15,000 per sitting. Oh, you will be here.
Yes, he will pay. Last time we bought.
Yes.
And we not, then equal.
15,000 per sitting, and the remuneration shall be paid by both the parties.
15,000, my lord.
Per sitting. What earlier? What was the fee?
15,000.
The same thing, I think so.
It's 12. My
Yeah,
last
12,000.
Come on.
12,000 girl. 12,000 per sitting, and both the parties shall bear the shall pay the remuneration of the commissioner in equal share.
My lord, may I humbly submit, my lord, kindly
The
pardon me.
remuneration of
My
the
lord,
court officer also, my lord, has to be.
lordship, my lord, the client is not in a position to pay that much, your lordship.
6,000.
6,000. Lordship.
5,000, 6,000 each. And the parties are also that under I am not recording that bearing of the cost because it is
shared equally.
share equal.
Lord,
If any other expenses with regard to the secretarial charges of the commissioner shall be bear by both the parties in equal share. The commissioner, the defendant is directed to file the affidavit of evidence of the defendant's witness. So that will be completed how much time?
Milord, I want, Milord, I request, Milord, last time I made all of them, Milord, I made this request, all of them objected.
What?
That commission should start at 10:30 and should continue up to 4:30.
Saturday, Sunday.
Saturday, Sunday. Yes, Saturday, Sunday. One Saturday, Sunday. It will be over.
But how soon you will file the affidavit of evidence, because you are
By Monday, your lordship.
not then the additional document
I agreed to everything. I say you take
by
your
2 weeks.
first
By 2
exception.
weeks.
Additional
No, Milord.
Below.
Milord, additional documents, they filed an application. I am agreeable to.
That I allowed. That I allowed.
Yes.
I allowed.
Affidavit of evidence, right, has come to an end. It's closed. If they give it to me today, I am ready to take it.
My lord, it will be served to my learned senior today only, your lordship.
How soon you will file?
Lordship, it is affirmed, your lordship. That is my instruction, your lordship. My lord, as my lord knows, my lord, there's a mishap in your lordship in a temple chambers, your lordship.
By today, filing within 2 weeks. Because they have a fire in their office building.
Yes, your lordship.
The
My lord,
affidavit of evidence be filed. Affidavit of evidence be filed by 19th of May, after serving the copy to the learned counsel for the plaintiff.
by Monday will serve, my lord.
By Monday?
My learned senior. By Monday, we will serve to my learned senior.
19 कर दो. Full stop. The commissioner is directed to complete to complete and to file the report before this court on how many witnesses? One witness?
One witness.
File the report before this court on 10th of June 2025.
Yes.
My lord,
10th June.
my lord, I have one submission, your lordship. Can the, my lord, this evidence part can, if it can, my lord, start after the vacation, your lordship, my lord, sometime, because your lordship, I'll tell your lordship what has happened, my lord. Mr. Ritobroto Kumar Mitra was assisting us in this matter. He was leading us, my lord. Then thereafter, after his elevation, your lordship, my lord, we have briefed Mr. Thakkar, your lordship. So, my lord, he needs some time to get ready. It's a voluminous brief, your lordship.
I have to cross-examine.
Cross-examine. Chief is already there. The
After vacation, your lordship.
Chief is already. You will file the chief.
We'll do it after vacation. Immediately after reopening, we'll do it and we'll file it by.
Yes, yes.
Kindly make it 15th June, Milord, if they
Report बोला है ना? By 20th June कर दो.
20th June.
By
After reopening, we'll do it. First
Lordship, I'm
weekend.
grateful to your lord.
GA.
And then leave.
5 is disposed of.
Leave for the plaintiff to file an additional judges brief containing the new documents.
The plaintiff is given liberty to file the additional judges brief document containing the additional document filed by the defendant within 2 weeks from date.
Lordship, grateful.
Lord, kindly, Milord, now it's 1:15. I'll take one more minute. Lord, kindly find us, Milord, 3 rooms in the court building. Kindly direct commissions from 10:30 to 4:30 in the court premises. like in Delhi High Court.
Girth of
Court will revive.
girth of space. That is the problem. That is the problem. We could not find any because
This new building has many floors, all full.
which our testamentary that's why we are not getting anything of the original side. All documents is lying there. All appellate side has been taken. Building.
This new building where upstairs your lordships
All
and
full.
chambers, all full.
All full.
Those courtrooms which were there,
All full.
stacked with court papers.
All.
Lord, acquire some property and Lord, let's
We are thinking that Mr. Chaudhary will give some
He's a
landed
public
property.
No, Milord, we must do something.
That's why I
really
feel, but my vision, what we are deciding in the vision, that is a space is vacant, but it is far from the court premises. Otherwise, it can be taken for the arbitration and the commission.
Very far from here.
20 minutes, Salt Lake. That is 20 minutes. That is the very far. That's why I am not. That's why I am not giving. But it is very good. Very.
No, we
good.
don't want.
But it is minimum. It will take 20 minutes. And here there is no space. I had a talk with the chief, but what can be done?
The next matter, my lord, it's only for fixing a date for my lord, cross-examination of the judgment date. Nothing.
Which one?
My lord, the very next matter, my lord.
Item number 11.
Cross-examined.
Item number?
Item number 12. My lord.
12.
The next matter. He was in the box, my lord. So if you like to could fix any other date, my lord, it's not concluded. We shall, my lord.
So and so Supreme for the degree holder.
11 is
Supreme for the judgment debtor. Examination of judgment debtor.
Examination of judgment.
Cross-examination.
Cross-examination was going on. My learned friend was there.
The case is fixed for cross-examination of judgment debtor, but due to paucity of time, the examination could not be done. Accordingly, case adjourned. Let the matter appear on.
Next week.
Next week it is not possible.
Week
After
that,
vacation.
After vacation. As your lordship pleases, my lord. I shall not.
My lord.
Your lordship.
No, examination of the witness. Cross-examination of the. नहीं है 10 11 12 13 एग्जीक्यूशन है ना 10 June at 3:45.
Grateful, my lord. Extremely
grateful. My lord,
Yeah.
item number 11 is an application for extension for filing the
Item number
11, my lord.
11 I already.
No, this is 12.
This is 12, my lord.
11, my lord, is an application for extension for filing the WS, my lord.
Who is for the plaintiff?
My lord,
He filed this application within 120 days.
Where is your written statement?
Written statement is with me, my lord. It has already been affirmed on 25th of April.
Why you not? Why you persons are not filing in the department?
My lord,
When 120 days is over?
it has not been over, my
When it is going to be over?
28th of May.
28th of May.
Yes, my lord.
Where is the application? Yes. What is your objection?
He has filed it within 120 days.
Hmm.
So, my lord, if he got the formal objection, my lord,
When you received the writ of summons?
28th of January, my lord.
28? Where you mention?
No, my lord.
28th of January.
Yes, ma'am.
Only sole defendant?
Yeah, no.
All defendant.
Defendant number 2. I am for the defendant number 2.
Only 2.
For defendant number 1.
What is you have filed the written statement?
No, your lord.
No. Okay. So and so appearing for the plaintiff, so and so appearing for the defendant number 2. You are appearing for? So and so appearing for the defendant number 1. Defendant number 2 had filed the present application being GA Com 3 of 2025, praying for extension of time to file written statement. Control for the defendant number 2 submit that the defendant number 2 has received the writ of summons on 28th of January 2025. After receipt of the writ of summons, the defendant number 2 has filed an application
For expunging the name.
Filed an application under Order 1 Rule 10 within bracket 2 of the Code of Civil Procedure for deletion of the name of the defendant number 2 from the array of the suit, from the cause title of the suit. Full stop. As the application filed by the defendant number 2 could not be hearing is going on.
Yes, my lord. Yes.
Could not be concluded, and as such could not be completed, and as such and due to which the defendant number 2 could not file the written statement within a period of 30 days, but the defendant has affirmed the written statement on
on 25th of April.
On which date? 25th of April?
Yes, it has been affirmed.
On 25th of April 2025, and that is within the outer period of 120 days. And if this court will allow the defendant number 2 to file the written statement, the defendant number 2 will file the written statement by Monday. Full stop. Counsel for the plaintiff raised objection and submits that the defendant number 2 has received the writ of summons on 28th of January 2025, though he has filed an application for deletion of the name of the defendant number 2 from the cause title, but he could have been filed an application for he could have been filed the written statement listed. He further submit that no cause has been shown by the defendant number 2 as to why the defendant number 2 has not filed the written statement within a period of 30 days. Consider the submission made by the counsel for the respective parties. This court find that though the defendant number 2 has not filed the written statement within a period of 30 days, but has affirmed the written statement within the outer period of 120 days and is ready to file the written statement by Monday, that is on 5th of May 2025, that is also within the outer period of 120 days. Considering the above, this court find that one opportunity should be given to the defendant to file defendant number 2 to file the written statement, subject to payment of cost of rupees 5,000 to the State Legal Service Authority.
My lord, kindly just take that course, my lord. I was waiting for that application to be.
Sure. Given one opportunity to the full stop. The defendant is directed to file the written statement in the department on 5th of May 2025 and 6th kar do. 6th of May 2025 after serving the copy to the learned counsel for the plaintiff. GA number and disposed of.
Grateful, my lord.
item 46 and 47 of today's list, my lord, under the heading for orders. My lord, the Ojha's matter. Your lordship had started hearing Mr. Shakoshen. In reply, my lord, Mr. Rupak Ghosh had completed his argument. My lord, any day, my lord.
What has happened to the appeal?
No, appeal, so they have preferred an appeal because
What
your
has
lordship.
happened?
They have preferred an appeal against your lordship's order, wherein your lordship has dismissed the suit. My lord, the honorable appeal court, my lord, remanded back the matter to your lordship and requested your lordship to hear out the review which was filed by them. So your lordship is hearing out the review now. The difficulty that, my lord, we are facing, that, my lord, the interim committee, interim board was formed by your lordship. Interim board had already taken steps, my lord, for revival of the company, is taking steps. Now till this review is being heard of, all the things are, my lord, shut down. That is the difficulty, my lord, we are facing every time. Your lordship, if fixes a date subject to your lordship's convenience, my lord, any date subject to your lordship's convenience, where your lordship can hear out the matter.
When?
Any date subject to your lordship's convenience with time, my lord.
Before vacation, there is no time.
My lord, any date, my lord. Any opportunity if be given.
Before vacation, I am only for 4 days.
দেখো না একদিনও যদি একটু ম্যানেজ করে দিতে পারো।
I am only 4 days. कौन है? क्या है?
Monday. My lord.
कौन सा?
Monday, my lord, if subject to your lordship's convenience, my lord, any time on Monday. This Monday.
Come after vacation.
My lord, any time. My lord, Mr. Sen had almost completed his argument.
Then he has to give the reply.
Mr. Ghosh has to reply. Monday হবে? 3 p.m. Monday. Deeply obliged, your lordship. Deeply obliged.
Record. So appearing for the petitioner, so appearing for the respondent. 46, 47. Huh?
Yes. 4 orders.
Respondent and counsel for the petitioner submitted, though the matter is fixed, matter has been parted and prayed for fixing a specific date and time, so the matter can be finally disposed of. In view of the submission made by the counsel for the parties, let the matter appear on 5th May 2025 at 3 p.m.
Deeply obliged, your lordship.
Yes, next. Inform the other side.
Yes, well, I have already informed they are appeared.
My lord, may I pay my lord's leave, my lord? That 283 matter, my lord, is appearing 58.
Yeah.
Here, my lord. It is marked parted, my lord. And whereby, my lord, honorable, my lord, Lordnet, my lord, John Tomito, my lord, senior advocate was appointed amicus curiae. But the appeal is yet to be filed, my lord.
Not yet filed.
It is under process. So, my lord, let it be after vacation.
Record an order 58. So appearing for the petitioner, as per the prayer made by the counsel for the petitioner, let the matter appear on 25th June. 25th June.
Earlier occasion, last one.
27 June. 27 June. Next.
Item number 1, I appear on behalf of the plaintiff. The lordship would recall that matter.
Yes.
Lordship, we are back to trouble your lordships with respect to this. This was a compromise decree.
Office report. Yes.
The lordship would recall this was on the limited circumspection that this was a compromise decree. It was a suit for partition. When we applied to the decree department for a copy, for a drawn up copy of the decree, an objection was made as to the fact that requisite stamp duty needs to be paid.
Correct.
On account of the fact that there is an ascertainment of right, interest, and title to the property.
Correct.
To that, your lordship, the learned advocate and record had proffered a judgment, rather elementary proposition of law for the purposes of your lordship, that the new judgment of the Supreme Court of India was Mukesh versus State of Haryana, your lordship. Sorry, State of Madhya Pradesh, I'm corrected, lordship. That in a compromise decree, apropos a partition suit, especially because no new right, interest, and title is being created with respect to the subject matter property. For the purpose of stamp and registration, it can be.
What is the property?
Your lordship, the property, if your lordship has the draft terms of settlement that was
coming under the Schedule 1.
Your lordship, under the Stamp Act. Your lordship, Probably not, your lordship. I'll just satisfy your lordship on that. Your lordship, if I may just address your lordship on one aspect first. Your lordship, the limited query that might fall from your lordship over here would be to ascertain if the properties that have been proffered as part of the terms of settlement are the same as which form the subject matter of the properties in the partition suit. Your lordship, if it is a new property that has been adduced, then your lordship, the question of stamping or registration that would come into play. Your lordship, with respect to that, your lordship, if I may just place the judgment once, I think so.
Who is for the other side?
I am for the defendant, your lordship. We are also supporting them. No
That's also
stamp duty is payable because it is a pre-existing right. And if your lordship takes the terms of settlement, all the properties comes from my predecessor in interest.
Yes, ma'am. So essentially, there is no new right, interest, and title in the said property. If your lordship, if I may just hand over a copy of the judgment of the Supreme Court, if it so commences to your lordship, although I need not embellish the wisdom of your lordship through any other judgments, there's a Delhi High Court which has followed that. Lordship, it is Mukesh versus State of Madhya Pradesh, reported as 2024, INSC 1026. That's the neutral citation of the Supreme Court. If I may just take your lordship to paragraph 3 once. If your lordship is with me, I'll just place it, your lordship. Originally, the facts in which the findings have been returned, your lordship, in this judgment. Originally, the appellant had filed a civil suit bearing number so and so before the court of the first civil judge, class 2, Badnavar, for declaration and permanent injunction against one Abhay Kumar and state of Madhya Pradesh, stating that he is the owner of the subject land and is in long and continuous possession of the same by doing cultivation. Then, your lordship, the averments that are there in the said suit, which was agitated over here, it's peculiar to that suit. So, your lordship, I need not trouble your lordship with that. Subsequently, if your lordship just comes to paragraph 6, your lordship, 6, although is the we have heard the learned counsel for the appellant and the learned counsel for the respondent number 1 and peruse the materials on record. Your lordship, as being fair to this honorable crime, must point it out that the contentions that have been taken note over here for the respondent number 1 have been on the premise that there is a new right, interest, title to the property. This is how the court has dealt with it, your lordship. Paragraph number 7. There are two issues involved herein. That is registration of the document and payment of stamp duty, which are separate and distinct concepts. As regards the issue of registration, we may refer to section 17 of the Registration Act, which deals with the documents of which the registration is compulsory, and the same is read as follows. Your lordship, over here the section 7 over here section 17 is reproduced. Lordship will kindly just take note of section 17 subsection 1 clause B. Other testamentary instruments which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of the value of 100 rupees and upwards to or in immovable properties. Lordship, over here the subject matter properties in the suit, of course, it's above the value of 100 rupees. So, your lordship, we are essentially affected by. Then, your lordship, the rest of the provision has been reproduced. If I may just then take your lordship to the finding of the court, it's an extension of paragraph 7. Your lordship would find it on internal page number 9. It is thus clear. Is your lordship with me?
Yes, yes, continue.
It is thus clear from the above section 17 of the Act 1908 specifies that documents for which registration is compulsory. Subsection 2 of section 17 carves out the exceptions. The documents, instruments enumerated in subsection 2 of section 17 are not compulsorily registrable. The exemption for decree or order of court is covered.
Yes, continue.
The exemption for decree or order of court is covered under section 17, subsection 2, clause 6 of the Act. Your lordship, I had placed section 17, subsection 1, clause B. That is essentially for the subject matter, but a specific exception has been carved out in section 17, subsection 2. I need not place it for given the wisdom of your lordships. Your lordship, if I may just continue. The exemption for decree or order of court is covered under in section 17, subsection 2, clause 6 of the Act with a rider. Under the said provision, any decree or order of a court, except the decree or order expressed to be made on compromise or compromising immovable property, other than which is the subject matter of the suit or proceedings. Now, your lordship, I do not think your lordship would have a copy of the plaint over here. However, your lordship will just take it from me. I've taken instructions also. The subject matter properties in these terms of settlement and that of the plaint are same. At the inception, I had pointed out that would be the limited query that your lordship might need to undertake. It would be relevant to point out that the provision permitting the compromise between the parties to include in the compromise decree the subject matter not forming part of the suit property was introduced with effect from 1st February 1977. Prior to that, the compromise decree can be passed only with respect to properties or subject matter of the suit. If a compromise decree involves immovable property other than property for which the decree is paid for, such a property would not be exempted and would require registration. This condition or the exclusion clause was introduced in the Registration Act 1908 by Act of 21, 1929 by substituting any award to avail the exemption of the mandate of compulsory registration of documents conveying immovable property of a value of ₹100 or more. This aspect, your lordship, we are not concerned with. Your lordship, then paragraph 8, it marries the factual aspects with the law that has been proffered by the Honorable Supreme Court. In the present case, seemingly, the appellant preferred civil suit number so-and-so against the respondents for declaration and permanent injunction, claiming ownership and continuous possession over the subject land and the same to be decreed in favor of him in view of the compromise arrived at between the appellant and the respondent number 2 on 30th of November 2013. For better appreciation, the order passed in the said suit is extracted below. Your Lordship, the order has been reproduced. Your Lordship, then internal page number 11, continuation of paragraph 8. In view of the above, the appellant is entitled to possession of the subject land. This is in view of the compromise settlement that has been arrived at. And the respondent number 2 shall not interfere with the same, and the appellant is entitled to get his name recorded in the revenue records in respect of the subject land in the place of respondent number 2. Pertinently, it is pointed out that the compromise decree has not been challenged by the respondent number 1 before any court, and hence the same has attained finality and is binding on the parties. Lordship, then if I may just kindly trouble your lordship and draw your lordship's very kind attention to paragraph number 10, your lordship.
Yes.
On internal page number 11 again, your lordship, the finding of the High Court has been discussed. We will not trouble your lordship with that again. Then again, section 17 has been reproduced, which has been discussed, and the exception that has been carved out has been pondered upon by the Honorable Court.
And you come to the page 18.
Yes, your lordship. That is the operative portion.
So which clause you are
Thus,
you are coming under all the 3 clauses?
yes, possibly, your lordship. That will be my endeavor. That
What is the suit for?
Your lordship, this is suit for partition, family property, partition of
ancestral property.
Ancestral property.
So you are having the right over the property.
Pre-existing right. I had my right over the property incepted off from the very moment when my father had passed away. The family. So there was already a pre-existing right. I had interest in the property. The title was there. By virtue of the compromise decree, all that has been done is that the subject matter property has been partitioned by meets and law. (11) is, your lordship, a previous discussion of the judgment of Muhammad Yusuf, which is the parent case on the subject matter. Paragraph 13, your lordship, is the discussion with respect to stamp duty. Just one thing, if I may just point out, your lordship.
Where is the plaint?
Your lordship, the plaint, I'll just hang it. Achha. Page 9, the plaintiff, your lordship may just incept off with.
What is your contention? How you applied for this decree?
Lordship, if I may just showcase to your lordship.
The property is recorded in your name.
The properties are currently, your lordship, I'll just have to seek instructions, my learned advocate on record, but as from what I was informed of at the inception, the properties are currently, it is recorded in the name of my father. It is recorded in the name of my father. Umashankar Changalal Dave. Lordship will kindly take paragraph 3 of my plaint. It expired on 17th of October 1999. Paragraph 4 onwards, the scheduled properties have been mentioned.
Where is the record of rights?
Your lordship, the record of rights, your lordship, perhaps is.
There is no.
Lordship, this was not part of my
then
plaint, your lordship. That is because the record of right is not part of my plaint, your lordship.
So
That
record
is
of rights.
one embargo that I'll be facing, your lordship.
Please do your record of rights. How it has come.
Your lordship,
That has to be decided.
That is to be decided.
Because kindly come to last 22.
22 of the judgment, your lordship.
Yes,
your
page 22.
Yes, your lordship.
Therefore, in the facts of case, consent decree will not operate as a conveyance.
Conveyance
The
as-
right is transferred.
I bow down, your lordship. That one aspect we need to satisfy, your lordship.
That is to be
with.
satisfied.
That is to be satisfied.
If it is in the name of the father,
your lordship.
so it has to be come to
Then
your
it will be conveyed.
convey.
That is one aspect.
If it is convey,
then it is conveyed, your lordship. Then that aspect I do.
that is to be.
Your lordship will just
If
kindly.
it is mutation has been done, it is recorded in your name, only the partition is okay, pre-existing right.
Yes, your lordship. My
But
last
you
instructions
got
were
the
that
property by ancestor property by
Yes,
way of inheritance. But still you got the inheritance, but still the property is recorded in your name, in the name of your
My
father,
father, that's
or
the-
grandfather, whatever it
Yes,
may
your
be.
lordship. In the,
So
that
if-
aspect I cannot.
So if it is transferred, so it can be a conveyance.
Lordship, perhaps your lordship, that
So
transfer won't
what is the meaning of the pre-existing?
pre-exist that aspect I'll satisfy your lordship
Because,
on, but perhaps
because
your
Hindu law,
lordship.
during the lifetime of the father, you
Yes,
cannot claim the property.
I cannot. Yes, your lordship.
You have no right.
It is only
You have
on
no
the-
a pre-existing right.
No, your lordship.
After the death of the father, you got the got the inheritance.
Yes, your lordship. More so, in fact, because the person concerned has died intestate, your lordship, my right or towards the property accrues only on the date on which he has passed away.
Correct. That's why.
1999 when he has passed away.
No, that's why.
That aspect I
That's
follow.
why,
your
but you have not gone for the mutation of the property.
That is one, your lordship. The instructions that I had obtained was that it was
You're not gone
in
for
my
the
name.
mutation. If the mutation is in your name, then
Then
partition.
there is a pre-existing right. Yes, your
Then
lordship.
partition.
Partition.
Then partition.
There is no
Court
new
pass an
right.
order, pass a decree for partition. Then the pre-existing right is already there. So there is no question of payment of the stamp duty.
I bow down to your lordship. That aspect I bow down. Your lordship, perhaps there is a Delhi High Court decision that I was impressing upon your lordship with the inception. But your lordship, the record of rights we need to just bring it before your lordship. We don't need to.
So suffering for the plaintiff, so suffering for the defendant. The matter is listed as on receipt of the report from the master. Police officer. This court has passed a decree on the basis of the compromise on the passed a compromise decree on the basis of the settlement arrived between the parties. Full stop. The plaintiff has relied upon the judgment passed by the Honorable Supreme Court in civil appeal number 14808 of 2024, arising out of SLP within bracket C number 4293 of 2021, Mukesh versus State of Madhya Pradesh and others, wherein and submits that in terms of the order passed by the Honorable Supreme Court, if the decree is if the compromise decree is passed with regard to the partition of the property, no stamp duty is required to be paid. Had the learned counsel for the plaintiff, counsel for the plaintiff press for time to place on record the record of rights of the property in question by way of supplementary affidavit within a period of 2 weeks from date.
2 weeks, your lordship will just kindly 2 weeks. No, it will come from. Your
4
lordship,
weeks.
just one thing. The record of rights in Gujarati.
Within a
Just
period
we
of 4 weeks from date,
translate it.
list the matter on 12th June 2025.
Grateful to
13 June 2025.
Grateful to
Next.
Lord, item number 2, my lord, I beg to appear for the plaintiff, my lord.
What is the name of your company?
My lord, POSCO India Processing Center India Private Limited. It's a big name, my lord. My lord, my lord, I had mentioned this matter, my lord, for correction, my lord, of my lord, the
What?
order dated March 10th, my lord.
What is the correction?
My lord, your lordship will kindly have a look at page 2 of the order once, my lord. My lord, your lordship was under the impression, my lord, for the purpose that the witness should not be harassed to remain in court for the whole day to wait his turn to adduce evidence, this court had specifically fixed the matter for witness action of the plaintiff with the consent of the plaintiff. My lord, since the adjournment was fixed and your lordship was of the view that the witness was made to wait for the entire day, my lord, had imposed a cost, my lord. But however, my lord, there was some, my lord, miscommunication perhaps, because on January 15th, my lord, when your lordship had fixed this matter on March 10th, it was fixed for hearing of the interlocutory applications being GA 1, 2 and 3, my lord. Witness action was not, my lord, there, my lord. In fact, the stage for witness action has not yet come, my lord. This perhaps, my lord, this error, my lord, perhaps crept in, my lord, when we got to see the order, my lord, and the advocate
Well, this
appeared.
paragraph in page 2, the first paragraph, this was possibly not, my lord, there when your lordship, because it was fixed for hearing of the injunction application. It was not there because the last paragraph of the first page, lordship had recorded their submissions and they were there, my lord.
We were there.
Lordship wanted the plaintiff to start on the interlocutory application, they could not.
No, perhaps, my lord, there were 2 more applications. One is an application.
Okay, I am correcting that. No problem.
And my lord, since my lord, the
Cost will remain same.
my lord will
but I will correct
my
that
lord will
cost
kindly
of
consider, my lord. My lord, there are 3 applications. One is an injunction application. One is an application under Section 8 filed by my client for reference of this matter to arbitration, my lord. And the other one is an application for rejection of plaint, my lord. The application for rejection of plaint, or my lord, the application under 8 for reference has to be heard, my lord, primarily first, my lord. Because if the suit is not there, the question of, my lord, moving the interlocutory application does not arise, my lord. So, my lord, it is, my lord, the defendant who has to, my lord, go ahead with the argument of their application first, my lord, before, my lord, the plaintiff, my lord, gives a reply to that, my lord. So, my lord, we don't stand in the way for them moving that application, my lord. My lord, the cost, my lord, your lordship will kindly consider perhaps was
I don't
given.
think my learned friend was there. Mr. Sen was there for the defendant. Mr. Sen offered to start his arguments. Lordship inquired from the plaintiff's advocate whether he will continue. Because he said no, he was not in that position. That is why Lordship had imposed this.
Sir, I was only beseeching if, my lord, your lordship will kindly, my lord, consider the cost, my
matter
lord.
is listed as to be mentioned for correction of the order dated 10th of March 2025. By an order dated 10th of March 20, in the order dated 10th of March 2025 at page number 2, paragraph 1 is recorded. It is recorded that inward comma only for the purpose that the witness should not be harassed to remain in the court for whole day to wait his turn to adduce evidence. This court has specifically fixed the matter for witness action of the plaintiff with the consent of the plaintiff. Considering the above, the case is adjourned subject to payment of cost of 50,000 to the State Legal Service Authority within a week from date. If the cost is paid to the State Legal Service if the cost is paid to the State Legal Service Authority, let the matter appear on 10th June 2025, 2 p.m. for witness action.
Well, it should be for, my lord, hearing.
My lord,
so inward comma close. Today, learned counsel for the plaintiff had drawn the attention of this court to the order dated 5th. Learned counsel for the plaintiff submitted that inadvertently this court has passed an order by imposing cost of rupees 50,000 upon the plaintiff on the ground that the case is fixed for witness action. But learned counsel for the plaintiff has drawn the attention of this court to the order dated 15th of January 2025, wherein it reveals that the case is fixed for hearing of the interlocutory applications and not for the witness action. In view of the above, considering the submission made by the counsel for the plaintiff and the order dated 15 January 2025, the order dated 10th of March 2025. The portion of the order. The portion of the order mentioned above. Portion of the order dated 10th of March 2025 mentioned above is recalled. Please let the matter appear on 10th of June 2025 2 p.m. for hearing of the interlocutory.
I'm deeply obliged, my lord. Grateful, my lord. I'm grateful.
Huh? Determination nahi hai. Not this court is not having determination.
My lord, because since, my lord, this is correction of, my lord, your lordship's order, that's why it was mentioned, my lord, before your lordship.
क्या बोला? Is recalled. नहीं, is recalled. Full stop.
The matter can go out of the list.
Full stop. It is fine that now this court is not having the determination. The plaintiff, the parties are liberty to mention before the appropriate court having determination.
My lord, I'm grateful, deeply obliged, my lord.
Yes.
My lord, I appeal for the executor, my lord. This matters come up on my instance, my lord. My lord, this is for correction of the order dated March 27th, 2025. My lord, I have a copy of the order, my lord.
What
my
is
lord, the issue that had arisen, my lord, is that, my lord, Mr. Shaha had appeared for the applicant in this. My lord, GA1 is an application for dismissal of my
what is the correction you tell me here? Story
the petitioner, my lord, the applicant and the petitioner, my lord, have to be interchanged, my lord.
That's
That is
all.
one. My lord, and Mr. Shannal did not appear for the.
I don't know who have given the name that has been recorded. That's all.
My lord, the
you persons are giving the name. I am not recording all
my lord,
this.
the order itself,
Yes,
my
call,
lord,
call the matter.
my lord, if my lord, I may.
For the change of the name of correction of name of the advocate, this court is not here.
My lord, the issue that had arisen, my lord, is that
You,
the order
you
itself,
go to the master.
my lord, if my lord,
you persons are giving the name. The court is not recording the name.
yes, my lord.
Then,
my lord, if one thing, my lord.
Sorry. Yes. Yes.
Revocation of section 92 leave. Lord, Mr. Rai was.
Yes.
First things first, my lord, the interim order is expiring today. That's the first thing, my lord. Then, my lord, may I just continue, my lord?
What is the interim order?
My lord, not to deal with the properties.
Yes.
And here, my lord, just a very short recap, my lord, if your lordship permits me, my lord, because it's come up after quite some time now.
Yes.
So, my lord, but here, my lord, there was this agreement, sorry, a trust deed, my lord. Just gives me one moment, my lord. There was this trust deed, my lord. Yes, I'm good. My lord, the trust deed, according to us, my lord, we said there is a public and charitable trust. My lord, we approached your lordship's court, section 92 leave granted, thereafter orders was passed. Revocation of leave, my lord, filed. My lord, 2 points basically taken, my lord. One is that it is not a public and charitable trust. And second was no leave under clause 12 of the letter spent has been taken because it's a suit for land. Now, when I, my lord, I was arguing, my lord, I had shown from the deed, my lord, that it is one of those trusts where, my lord, alms were supposed to be given to the poor also. Education dharmashala was also there. So I submitted before your lordship that my lord will kindly restrict your lordship's view to the pleadings made by them. They have said fraud. Fraud is a question of fact. And next, this is a prima facie view that yes, it is public and charitable. And I had also said that my lord will kindly appreciate that here the plaintiffs have never asked for any orders, my lord, which would be beneficial to the plaintiff. Nothing in their favor, my lord. It is only to safeguard the property of the trust. So that is what the submissions were, my lord. Now, my lord, with regard to my lord, leave under clause 12, my lord, I had shown that the principal office was within the jurisdiction. So I had relied on my lord, section 90 to show that it's within the jurisdiction, and therefore, my lord, leave under clause 12 would not be required. And I also shown, my lord, I'll refer to a judgment, my lord, that once, my lord, section 92 leave is granted, this is the nature of a complete court. Section 12, leave under clause 12. But I'm feeling a bit, my lord, I know senior lordship gets so angry, my lord, that's why I'm also feeling a bit. Sorry, my lord. Leave under clause 12 of the letters patent. Leave under clause 12 of the letters patent, my lord, is not required. So that is my submissions, my lord. These are my submissions. My lord, may I, if your lordship wants, I can again show the clauses. If your lordship says that it's not required,
You're already
done. Now, my lord, may I go to the judgments, my lord?
Correct. You have taken all, you have recorded?
I have, yes.
You have taken note of it?
Yes, my lord. Oh, yes, my lord. I also forgot, my lord. I had also tried to show, and I'm sure your lordship has recorded it. It's in respect of the Income Tax Act and Section 80G, meaning of charitable.
Yeah,
and
charitable and religious trust, 1920.
Yes, my lord. That is also what I had mentioned, my lord. And in this case, my lord, 80G is a section which the deed also provides for that.
Charitable Endowment Act, 1860. Section 2, definition of charitable.
Yes, my lord. So therefore, this is also a charitable endowment, my lord, trust. Now, my lord, may I start with my judgments, my lord, and then I will deal with my learned friend's judgments. My lord, this is to counter my learned friend's submission of revocation on ground of territorial jurisdiction.
Yes.
Plus 12, plus 12. Well, this is reported in 2019, 12 Supreme Court cases 205.
Yes.
My lord, I'll be referring to my lord. Oh, it's 205. And I'm referring to my lord, para 14 to 24.
Yes.
My lord, main paragraph is, my lord, paragraph 17 and 18, my lord, following the old judgment of Justice Rankin, my lord, that these questions of territorial jurisdiction should be kept for the trial, not at the very threshold. It kindly takes paragraph 18, an issue of such nature. An issue of such nature, in our view, cannot be tried by filing an application for revocation of leave. Indeed, that is what Chief Justice Rankin, the then Chief Justice, held for the bench in Golabrai Paliram case. That is, as a matter of set out in paragraph 15, and which received approval of this court in Indian Minerals and Chemicals Company. In our opinion, a plea of territorial jurisdiction is essentially a mixed question of law and fact. It is for this reason the respondent defendant should be allowed to raise such plea in the written statement to enable the court to try its own merits in accordance with law. In the light of the requirements of Order 14 and other relevant provisions governing the issues on merits. The easy route. This was the easier route, my lord, which I'm trying to get, my lord. Other than that, now, my lord, kindly takes.
That is the thing decided by our division bench.
Yes, sir.
In the La Martini case.
Yes, my lord.
The Justice Mukherjee has held that it should be a preliminary issue and
an Order 14 rule. And I also thought so, my lord, because revocations once granted, well, becomes a question of fact.
Yes.
In consequence.
That to 92. That is with regard to
92, my lord. My next judgment is done away. Well, this is reported in AIR 1955 Bombay. My lord, Fazal Hussain, Haldar Bhoy, Buksam Musa, and others. And versus Usuf Ali Adamji. Well, I think I won the bet. I told him that I will pronounce it one shot, and I did. My lord, kindly takes paragraphs 12 and 13. But the facts are enumerated. So, no, Para 6, my lord. The question that arises then for decision is this court competent to entertain a suit for the administration of charity and for removal of trustees and for appointment of new trustees in the charity is to all intents and purposes a foreign charity. The management of the charity is carried on in a foreign territory and the trustees are non-resident foreigners. Merely because some of the properties which belong to the charity are situated within the territorial jurisdiction of this court and its income is collected and is required to be applied for the purpose of the charity. For the decision of this question, I have omitted for consideration the state of things which prevailed when the suit was filed. I am not going to that. Malad, kindly straight away comes to Malad, para 12 and 13. In my view, clause 12 of the letters patent can only apply to those cases regarding which no provision is made in the Civil Procedure Code relating to the jurisdiction of this court. Normally, the territorial jurisdiction of court has to be ascertained by reference to provisions of section 16 to 20 CPC, but by reasons of the express provision made in section 120 CPC, provisions of 16, 17, and 20 do not apply to this court in the exercise of its ordinary original civil jurisdiction. The jurisdiction of the High Court to decide a suit in the exercise of its original civil jurisdiction required to be ascertained under clause 12 of the latest patent. Ordinarily, therefore, if a question as to the jurisdiction of this court to enter in a civil suit is raised, the question would have to be decided by reference to the provisions of clause 12 and not section 16. Absolutely, Malad, that is the law, Malad. Now, Malad kindly takes just 4 lines from the bottom of that paragraph. It does appear that there is a conflict. Lordship has got that, Malad? Yes. It does appear that there is a conflict with the terms of section 92 of the CPC and clause 12 of the latest patent. But in the event of a conflict between the latest patent and civil procedure code, the latter issue must prevail. Sorry, latter statute must prevail. Clause 44 latest patent provides that the provisions of the latest patent subject to the legislative power of the Union Parliament. The jurisdiction of this court must be ascertained solely by reference to the existence or otherwise of property with the subject matter of the suit and not by the reference to other constituents of the residence of the defendants or the cause of action or part thereof arising in the jurisdiction. I am supported in that view of the case by a decision of the Calcutta High Court reported in Padampat Singhania's case. In that case, Mr. Justice Buckland has observed the words in the section 92 referring to the subject matter of the suit are referable to both courts mentioned. If that view is correct, this section must be taken as overriding clause 12 of the latest patent, which permits a suit to be instituted in this court if the defendants at the time of the commencement of the suit shall dwell or carry on business or personally work for gain within the local limits of its original jurisdiction, for otherwise one would have to ignore the mandatory provisions of subsection 2. Admittedly, 3 of the provisions areas to be subject matter are situated within the limits of this code, and therefore this went on to hold that no clause 12 of the latest patent will be subservient to section 92, Malad. But only one thing, Malad, kindly, your Lordship will find at paragraph 33 and 34, Malad. It must be observed that the application for leave to file the suit under clause 12 latest patent was not necessary in para 33. And then 34 does not appear to have been pointed out to the Lordship. The suit was filed was not governed by clause 12, but the jurisdictional code was derived with the terms of section 92 of the Code of Civil Procedure.
Yes.
Then just for a follow-up, Malad, Padampat Singhania's case, Malad, which has been mentioned in this earlier 1955 Bombay, Malad.
Slightly.
Malad, we have a copy, Malad, where there's a bit of an endorsement. I'm sorry, Malad, on the top right, Malad. That only refers to that it has been cited in that other judgment of Bombay, Malad. Only that much. Malad, paragraphs 14 and 15.
Which year?
Para 15, 14, 15. No.
Which year, Judgment? 21.
No, I'm sorry. I'm sorry.
Yes.
Malad, yes, Malad. Kindly takes, Malad, 1, 2, Malad. This is Calcutta series, page 3, Malad, 359, Malad. Internal page 359. Last para, this is a suit under section 92 of the code, which provides that in the circumstance stated at the beginning of the section, consent of the Advocate General, a suit may be instituted in the principal civil court of original jurisdiction or any other court empowered in that behalf. Then my lord notes subsection 2. Then my lord kindly sees my lord, it is contended that no part of the subject matter of the trust was within the local limits of jurisdiction of this court at the time when the suit was instituted. And in consequence, this court has no jurisdiction. This contention was met in the first place by Mr. Roy on behalf of the plaintiffs by the argument that though the section authorizes suits in courts within local limit of jurisdiction, whole or in part arises, it does not exclude the provisions of clause 12 as the defendants also reside or work within the local limits.
Yes.
Why have this feeling someone is patting me from the back? Very strange, but I'm always having the feeling that someone is patting me from the back. I don't know. Now, my lord, if the words referring to the situation of subject of trust,
It is better some of the junior may sit in behind you.
I don't know, my lord. I'm really feeling this is as a matter of fact, it's the fourth time I've been turning around and trying to find out what's happening.
So what you taken in the lunch?
Nothing, my lord. Not at least, my lord. The unmentionables I haven't taken them as yet. My lord, the last sentence in that page, 360, in my view, the words in the section referring to the subject matter of the trust are referable to both courts mentioned. If that is correct, this section must be taken as overriding clause 12 of the latest patent, which permits a suit to be instituted in the suit if the defendant at the time of the commencement of the suit shall dwell or carry on business or personally work for gain.
Yes.
So, my lord, this is my lord, the Padmavat Singhania case, my lord. Then, my lord, Varghese. And then, my lord, kindly takes, my lord. Rajinagar to কোথায় আমার ক্ষেত্রে নেই দেখি no my lord, this is my lord 2012 one Supreme Court cases 369. Now, my lord, from clause 12, my lord, I'm now shifting to, my lord, section 92 and its scope, my lord.
Yes.
And straight away, my lord, will kindly come. My lord, kindly takes para 31, my lord. As can be seen from this section, two or more persons having interest in the trust may institute a suit in the principal civil court of original jurisdiction to obtain a decree concerning a public charity for various purposes mentioned therein. Such suit will lie where these persons make out a case of alleged breach of any trust created for public purpose or for direction of the court for administration of justice of the trust. One of the purpose set out in 1G is settling a scheme. Malad, this is there in my prayer, Malad. Subsection 1B speaks about a new trustee being appointed. Subsection 1A speaks about removing a trustee. Malad, both these prayers are there, Malad. But it is not the plaintiff. We have not asked for the plaintiff, Malad. Then, Malad, out of the 3 persons who filed was a member, Malad, doesn't need. Then comes to 32, Malad. Subsection 2 of section 92 lays down that a suit claiming any of the details present in subsection 1 has to be instituted in the conformity of that subsection. Such suit having been filed, the trial court here finding it is a public trust and not a minority institution. That finding has been left undisturbed by the High Court and confirmed by bench of 3 judges of this court. Although the trial court declined to accept the principal prayer of such and such, the division bench in appeal realized that an appropriate scheme, the administration of trust, was necessary. And accordingly, Malad will kindly see when an administration of a scheme is required, Malad, that is also deemed to be a public purpose, Malad. Malad, these are our judgments, Malad.
Yes.
It's notice it. Now, Malad, may I deal with the judgments thrown by Mr. Ghosh and related upon by him. ওইটা জিজ্ঞাসা হচ্ছে আমি এটা করেছি Well, the first one is which I'm trying to distinguish 1975 one Supreme Court cases 298 Charan Singh Malat.
1975.
75 one Supreme Court case.
Charan Singh, yes.
Charan Singh Malat. Right?
Yes, regard upon paragraph 7.
7 Malat.
Yes.
It just gives you a moment.
7 and 10 also.
Okay. Now, Malat kindly sees paragraph 7. The High Court in the latest patent appeal has taken the view that the relief sought for in the suit does not fall under clause 12. Clauses of A to H of section 92. So, my lord, your lordship will kindly appreciate the High Court had made a factual finding there. Today, my lord, learned counsel for the appellant has assailed this view and submitted the relief sought for falls under clause E or G,
or any event,
or in any event under clause H. In our judgment, relief sought for in this case does not strictly or squarely fall within clause E or G. It's very much akin to either and hence is covered by the residuary clause H. Now reads 8, my lord. Yes. Now, my lord, Lord Sinha, delivering the judgment of the Judicial Committee of the Privy Council in Abdul Rahim, rejected the argument that the words such further or other relief as the nature of the case may require or occurring in clause H must be taken not in connection with the previous clause A to G, but in connection with the nature of the suit. The argument was that any relief other than A to G in the case of an alleged breach of an express or constructive trust as may be required in the circumstances of any particular case was covered by clause F. It was repelled on the grounds that the words further or other relief must be on general principles of construction be taken to mean relief of the same nature as clauses A to G. Now, my lord, kindly just comes down to, my lord, your lordship will find in inverted commas or will mean or. Just after that. Yes. The other relief, however, cannot be of a nature which is not akin to or of the same nature as any of the relief mentioned in clauses A to G. Accordingly, according to the plaintiff's case, one of the objects of the religious trust was the worship of Granth Sahib and his recital in congregation of the public. In the suit, a decree declaring what portion of the trust property should be allocated to the said object could be asked for under clause E. The plaintiffs could also ask for settling of a scheme.
Yes.
Under clause G, alleging mismanagement of the religious trust on the part of the trustees. In the settlement of the scheme could be included the worship and recital of Granth Sahib, the Holy Granth. Plaintiffs in the plaint did not in terms ask for the one or other. Well, this is the distinguishing factor. Neither of it was wanted. They wanted a decree of the court against the appellant to force him to carry out the objects of the court against the appellant, objects of the trust and to perform his duties as a trustee. Reading the plaint as a whole, it is not a suit where the plaintiff wanted a declaration of their rights in the religious institution in respect of the Granth Sahib. But it was a suit where they wanted enforcement of due performance of the duties of the trustee in relation to a particular object of the trust. It is well said in the maintenance of the suit under section 92 depends on the allegations of the plaintiff and does not fall for decision with reference to the above mentioned the written statement. And lastly, my lord will kindly come to paragraph 11.
Yes.
There were two parts of the said relief. One, a declaration the plaintiff as Bhagats of the Satra were entitled to possess their own basti and paddy lands, and the other that they had a right to access the use of the Satra for various religious relief. Such a relief could not come under clause H because it was mainly concerned with the establishment of the rights of the plaintiffs in the land, as well as in the religious institution. In the plaint of the instant case, the relief claim is not primarily for the establishment of the right of the public to the religious institution. It recites the facts as to the right without mentioning any appreciable dispute concerning, mainly alleges breach of the part of the trustee. The plaintiffs seek the court's aid against the trustee for forcing him to discharge his obligation by due
performance of duty.
By due performance of his duties. In our judgment, therefore, the court below was right in taking the view that the present suit was a suit for a decree under section 92, and since it was not filed in conformity to the requirement of said provisions, it is not maintainable. I think there is a mistake in that. But whatever it is, my lord, the holding was that if, because here they have asked for specific rights for themselves as plaintiffs. That was the, my lord, distinguishing factor here. Next, my lord, will kindly see. This is the case of Mohesh Tulsian, my lord, if your lordship kindly sees, 2011 2 CHN 169.
Yes.
My lord, Mr. Ghosh had referred to, my lord, several paragraphs, but my lord, I would like to refer, my lord, kindly takes paragraph 8.
Yes.
What is it? And it says, on careful perusal of this reading of the said contention clearly discloses cause of action for vindicating individual right, namely to establish himself with the principal trustee on one hand. Again, my lord, personal rights were trying to be enforced here. My lord, kindly sees the prayers at paragraph 9. Prayer A, my lord, is a prayer which was for his personal benefit, the plaintiff's benefit. Now kindly takes paragraph 10, my lord.
Yes.
My lord, kindly sees Lakshmi Devi versus Hansraj Gupta was my lord, referred to. My lord, your lordship will kindly find within the italics, my lord, that was the distinguishing factor. A suit brought by trustees on their own behalf.
Which paragraph?
My lord, 10. Within the inverted commas, my lord.
In the case of Lakshmi Devi?
Yes, my lord. In the inverted commas, my lord, you will find just after Calcutta 789 in that quoted portion, seems to be basing on these, or it can be concluded that a suit brought by trustees on their own behalf in the discharge of their own function as trustees, not being a representative suit, and is outside the scope of section 92. And that is why, my lord, it was dismissed.
Yes.
Then, my lord, will kindly see what is just speaking from? Huh? Huh? Then, my lord, it's my lord, this is 1991, one Supreme Court cases, page 48, my lord. This is, my lord, R.M. Narayana Chettiar versus L. Lakshmanan Chettiar.
Yes.
My lord, this I'm not in. My lord, I'm not really going to dispute. It's a question of law, my lord, whether a notice is to be given or not. But it provides that if notice is not given, they have a right of revocation of grant, and they have made that application. So I don't see much in it in this judgment, my lord, which is required to be distinguished as such. My lord, your lordship will find it paragraph 16. There the question.
Yes, last 17 last paragraph.
Yes, and 16, yes, last paragraph.
However, the consequence is you can file an application for
That's it, my lord. So this is basically, I don't think, my lord, it is within the disputed questions, my lord, which is now being argued upon. Then, my lord, is AIR 1983, Calcutta 420. Sounds good, eh? 420. My lord, clause 12, suit for land.
that you already distinguished.
I've distinguished it. No, I have not distinguished this judgment. I've distinguished in law, my lord, and in
no paragraph 15.
15 I have. Oh.
Paragraph 15.
My lord.
Correct.
My lord. And not only that, my lord, I have not asked for any specific prayer for any land also. My lord, suit for land is a suit where, my lord, I ask for certain right, title, or interest in a land.
In
a land outside the jurisdiction of this court, then leave under clause 12. I have not asked for any such prayers also. And I have my principal office within, my lord.
Yes.
But Atcons is very clear, my lord. If your lordship once again refer to that, but I think it's very clear.
Okay.
Now the last two judgments, my lord. কোথায় গেল রে? My lord, two of the Vidyodaya Trust judgments. First is 2006 7 Supreme Court cases 452, my lord.
That also you referred to.
I have referred to, I have said that this from a revision from a final decree. And my lord, 2008 4 SCC 115. My lord, yes. Your lordship, they have referred to paragraphs.
Paragraph 3.
Paragraph 3, 4, 6.
They have referred the paragraph 3 and 11.
3 and 11, my lord, kindly comes to 13, my lord. Sorry, my lord, 13, not 13, my lord.
Which 2008?
Yes, my lord.
2006.
This is 2008.
2000, no, they have referred 2006. 2008, they have referred 18 to 23.
Yes, my lord. That's what I thought. My lord, kindly takes, my lord.
And you have referred
para 15, my lord.
4 and para 17.
That was the case, the facts. Para 15.
Yes.
My lord, R.M. Narayan Chettiar has been looked into, my lord. Then, my lord, kindly comes. They have referred to paragraph 18, my lord.
Yes.
Prior to legislative change, my lord, just below that, my lord, the object of section 92 CPC is to protect the public trust of a charitable and religious nature from being subject to harassment by suits filed against them. Public trust for charitable and religious purposes are to run for the benefit of the public. No individual should take benefit from them if the person in management of the trust are subject to multiplicity of legal proceedings. Funds which are to be used for charitable or religious purpose would be wasted. The harassment might dissuade respectable and honest person from becoming trustee of public trust. Thus, there is need for scrutiny. In the suit against public trust, an analysis of the above contained in the plaint. It transfers the primary object behind the suit was the vindication of individual or personal rights of such person and action as under provisions does not allow. And Swami Paramanathan case is referred to. Then, my lord, kindly sees para 20. In Swami Paramanathan's case, it was held that it is only the allegation of the plaint that should be looked into at the first instance. I have been showing from my plaint, my lord. And then, if after evidence taken is found that breach of trust has not been made out, the prayer for direction of the court is vague, is not based on solid foundation, then, my lord, the revocation will be done. So it is also from his judgment, my lord. I say that the test is that at the very first, you are not supposed to throw me out. So, my lord, these are the judgments which have been referred to. And accordingly, my lord, I would like to submit that, my lord, leave ought not to be revoked, my lord. Now, my lord, with regard to the application, that is also before your lordship, GA1, where I'm trying to enjoy an interim order, my lord. We have not argued on that. I don't know whether your lordship would want this to be first complete and then GA1 to be taken, or I can again argue complete. I'll do GA1, my lord. Yes. GA1. জীবনটা তো এটা ঠিক আছে করিস ঠিক আছে তাহলে GA1 ও
फिक्स है क्या फिक्स मैटर है
and this is a fixed matter but we don't have the judgment for it. I've been told
okay come on the next census and suffering for the plaintiff, census and suffering for the defendant. Counsel for the plaintiff has concluded his argument in connection with GA3. No? GA3 of 2022. Please. Counsel for the plaintiff plays for time to argue the matter in connection with GA1 of 2020. Accordingly, case is adjourned. Let the matter appear on 13th June. 13 June.
Time fixed or interim order? But it could be on the 25th.
25th June. Then 27 June.
But the interim order may be extended.
Interim order. When it is going to expire?
Your lordship is making on day-to-day basis.
The interim order due to expire today is extended till 27th June 2025.
But may I take this occasion to apologize on behalf of Mr. Shayak Mitra, my lord. But I understand the person who was submitting before your lordship, my lord. He's my chamber junior, and I will tell him, my lord, he was being a bit more persuasive, my lord. I'm so sorry for that.
Order passed March.
I understand, my lord.
May they are mentioning that to correction of the
The
advocate.
problem is, my lord, solicitors, they press the counsel. So, my lord, well, that's why I told him that stop, don't make further submissions. Well, I tender my apology also for his, on his behalf, my lord.
Yes, next.
My lord, this is lordship was hearing, my lord, the suit and my lord, the witness action. Now, my lord, my learned friend has filed an application for appointment of a commissioner. Now, my lord, there was a direction passed, my lord, to use an affidavit. Now, my lord, we were unlucky, my lord, the person who was supposed to, my lord, affirm got transferred. So now we are ready because the new manager has come. So, my lord, I was humbly seeking for an extension.
What is the application?
Appointment of a commissioner to record the evidence.
Direction was to file affidavit by 20th March.
20?
Yes, I am in
Twice-
default. I am in
twice
default.
we have mentioned.
I am in
upon
default.
notice, they didn't even appear.
I am in default. Absolutely, I am in
That's
default.
all. That doesn't have, there's nothing.
Today, my lord, I have my affidavit in hand.
Affidavit in?
In my hand, my lord.
Opposition?
Opposition.
You are objecting. Why you objection?
My lord, in my affidavit in opposition, the primary ground which I have taken is, my lord, the reason given by them is they can travel to Calcutta for commission, but not travel to court, my lord, for my lord, recording the
The
evidence.
hot environment of the court.
And your lordship is, my lord, kind enough, my lord, because your lordship usually fixes a time, my lord, for the evidence. And this is not a ground. Secondly, my lord, the cost aspect is also there. Well, honest friends, my lord, clients are a company, big company. My lord,
May I be? This is
of
Central
course.
Bank of India I'm talking about. May I
That's
be blessed
right.
with a
Public
copy of
money,
the-
public
May I
money.
be blessed with a copy of the affidavit?
Yes, yes, absolutely, absolutely. My lord, may I file my affidavit?
Reply.
We'll use the reply because I am yet to see what's there.
So suffering for the plaintiff, so suffering for the defendant. Counsel for the plaintiff has filed affidavit in opposition in connection with GA
GA
9.
9.
GA 9 of 2025. After serving the copy to the learned counsel for the defendant, let the same be kept with the record. Counsel for the defendant press for time to file affidavit in opposition. Affidavit in reply. Defendant number 1. So who is for the other? Reserve Bank, nobody.
Nobody is appearing.
Counsel for the defendant number 1 press for time to file affidavit of reply. Let affidavit in reply be filed within 1 week.
1 week? 1 week.
Within a week. Release the matter on 22nd. No, 23rd May.
23rd. Great.
Next. Parted. वो चले गया लगता. You are appearing?
Yes, sir. Lordship, the respondents were to conclude their arguments.
My lord, I am appearing on behalf of the respondents, my lord. I was led by Mr. Probal Mukherjee, my lord. My lord, this matter was stipulated to appear on 2nd April, my lord. The matter was stipulated to appear.
Well, I am appearing, my lord, for that matter relating to the revocation of the power of attorney.
Correct.
Yes, my lord. If your lordship
They
can-
were in the midst of making their submissions, and then they said, my lord, I don't know, my lord, they wanted us to have some settlement, but I don't think there will be any settlement.
No, my lord.
No settlement reached.
No, my lord.
So what can be done?
Kindly fixes any date. Mr. Mukherjee will come and conclude his argument.
It's fixed today.
Yes.
My lord, it was not. It was supposed stipulated to appear on 2nd April, my lord.
2nd April. After that, it had appeared. I think there was time was taken.
On 2nd May, 1 month time is given to you by the court automatically.
My lord, if your lordship can fix it any day, my lord.
But then let us do one thing, let them, we shall all file our notes because he has already made submissions on 2 occasions. It is.
When he will be available?
My lord, any day before 16th, my lord.
Before 16th of?
16th of this month, my lord.
May?
Yes, my lord.
Why after 16 not?
My lord, he will not.
Vacation starts, my lord, for him.
Sense appearing for the plaintiff, sense appearing for the defendant, counsel for the defendant prays for time due to personal prays for time, full stop. Let the matter appear on आज की ना 2 तारीख है. Every Friday I am taking. That is
next Friday. Your lordship will keep it next Friday.
Next Friday is holiday. 9th.
Oh, next Friday is holiday.
Holiday. Then 16 is the last working day. Then 16 on 16th May 2020.
Obliged, man.
Nine, my lord, I'm praying for accommodation, my lord.
For?
This is, my lord, I'm replying to an application, my lord, for rejection of plaint. That I'm led by Mr. Obrojit Mitra, my lord. I have to get him ready in this matter, my lord.
Sense appearing for the plaintiff, sense appearing for the defendant. As per the prayer made by the counsel for the plaintiff, case is adjourned. Let the matter appear on 13th June.
Very
good. ये देखो है उसको मिलो मिलाप चुरा रही है फिर भेजा कुछ.
My lord, I am Milap Choraria.
Yes.
My order is removed from website. Order dated 26 March 2025 is removed from the website.
Removed from the website?
Yes.
See? CS 250 2011 ये यहाँ में क्यों है? काटेड है क्या? काटेड तो नहीं होगा.
My lord, I am cataract operation was held my eyes.
Just a minute, I am checking whether it is removed or not. Order dated 26 March. क्या ये जीपी कौन है? Why it is not uploaded? Why it is not uploaded?
Earlier uploaded, then removed.
Uploaded?
Yes, I have copy.
So how it is in...
Then it is removed. And order dated 27th February is also changed. Where the 26th March was changed as 6th February and 6th March.
None appears on behalf of the plaintiff. Defendant number 1, Mr. Milap Choraria, is present in person through virtual mode. He submits that the order dated 26th March 2025 passed by this court was initially uploaded in the website of this court and subsequently it has been removed from the website Subsequently, the order dated 26th of March 2025 is removed from the website. After hearing Mr. Churaria, this court directed the assistant registrar of this court to check the website in court itself, and when it was checked, it was found that the order dated 26 March 2025 is not in the website. Accordingly, the registrar IT is directed to submit the report whether the order dated 26 March 2025 was ever uploaded in the website, or if it is uploaded, under what circumstances the order has been removed from the website of this court. Let the explanation be filed before this court within a week. By
next week, my operation, second operation will be held. My next week, my second operation of the eye is also will be held.
Okay, 13th June, I am fixing now.
13th June.
Yes.
Okay, okay, sir. Okay.
13th June 2020. By 13th June.
Thank you, my lord. I have copy of the order dated 26 March.
Okay, I will see to that, how it has been removed.
Your Lordship, we are appearing for the propounders.
Yes.
We are in reply.
My lord, I am appearing for the defendant number 2 to 4.
Your Lordship, we are in reply, and on the last occasion, Your Lordship had pointed out around 4 questions, posed 4 questions that Your Lordship needed clearance on, asked us to clarify. One was being that why the 21 years of delay of filing probate. Second, signature of the testator, the disputes regarding the signature of the testatrix. Mutation, it was submitted by the caveators that the mutation was completed in the year 2002. I shall proceed to show that it was not so. And property, Your Lordship had pointed out that the property had belonged to Mr. Priyolal Banerjee and Kiranwala Devi. So how, therefore, did she proceed to bequeath the property in its entirety to the propounders here?
Alone.
Your Lordship, as far as the signature of the testatrix is concerned, all right, sir. May I proceed to show the mutation? Mutation, I show the mutation.
Yes.
May I?
Milord, 5 questions, Milord, was raised, Milord. Preliminary on Milord on the question of suspicion and delay. And delay and suspicion were brought together to cook up a story of suspicious circumstances. But Milord, I find that the entire attempt
तो फिर क्या देगा? ठीक है, मॉडल. Yes.
Now, Milord, the attempt of my learned friends was to, Milord, show that so far as the petitioner is concerned, who is, Milord, the applicant for letters of administration, his conduct is not beyond doubt. That is the entire effort. In fact, Milord, the last submission made was that he was not a credible witness because he had knowledge of the will from 2002. He got the property mutated on the basis of some document which he presumes to be the will, and thereafter it is suspicious. Now, Milord, 2 things are very cardinal and very of importance. One is, when we say suspicious circumstances, it doesn't rest there. The word is suspicious circumstances in the making and preparation of the will. That is all. Suspicious circumstances post-will will not create any doubt. That is, their endeavor was to show that there was suspicious post-will. And I'd show that this post-will suspicion, A, is not correct, B, is of no relevance at all. Second thing, my lord, is they are trying to say that there has been delay of 21 years or 12 years, whatever it is, there has been great delay. Now, delay becomes important when the will surfaces after the demise, a considerable time has lapsed, and all of a sudden a will surfaces to which the legal heirs are taken by surprise. The presumption is that if there is a delay, then the likelihood is that the will has been procured, or it's a manufactured will. The deceased died without leaving a will. In the instant case, the execution and attestation of the will, which I have proved by virtue of 63 and 69, was not challenged and questioned. And I had noticed that when my learned friend was relying on the judgment of 2002 to show limitation, the last line of that judgment says in that is that if the execution and attestation of the will is proved, delay is of no consequence. Now, my lord, all that I have to show to your lordship, my lord, that so far as the execution and attestation of the will, there has been no challenge, no argument on that. The only argument that they have made is had the applicant come earlier, then in that event, we would have got an opportunity to cross-examine the witness. That opportunity is gone. That's the only point.
Not on that, yes, only point, but they have taken the other way. You have waited.
That's not correct.
You have waited till the death of the assessor.
So first, let me do away with that.
After the death, you have filed.
First, let me do away with that first. That's the submission. Now, my lord, the premise on which they make this submission is on the basis of an exhibit which, my lord, they had filed, which is Exhibit 1. Exhibit 1 मेरा तुम्हारी पास है. Not that one, that's PDT. The supplementary. They have exhibited by way of supplement judges brief of documents, my lord, defendant judges brief of documents, if your lordship takes. It is. Yes. Take out the mutation certificate. No, where is it in the exhibit and the question numbers?
মিলা
এইরকম একটা হবে দেখুন.
Second judge. क्या है इसमें नहीं है ना? Yes. Exhibit 1.
Yes. Well, they say that we had made an RTI application, and on the basis of that RTI application, this was what we came to know from the Kolkata Municipal Corporation on 13th of October 2015 to Nobonita Mukherjee, that is Miller the Caviatrix, Shoila such and such, RTI application received on 5th August 2015 under RTI such and such. With reference to the above subject, as per the available records, books of records and reported by the department concerned, the following point-wise replies were given to you for your perusal. Please. Name of the recorded owner with effect from GR 1972-73 to GR third quarter so and so, Pyarelal Banerjee and Kiran Baladev. Then, Vide mutation case number, kindly mark this, my lord. Vide mutation case number 058, 28 June 2013.
Yes.
Stroke 76529, dated 1st October 2002. the name of Indrajit Banerjee is found to be recorded as the recorded owner against the subject. As reported, since the mutation took place long past, since the best search, the file cannot be traced. My lord, pausing here for a moment, the mutation certificate was exhibited in this proceedings. That your lordship can take a note. It's question number 201
of PW1
of the caveatrix. The caveatrix was confronted with this.
DW.
It would be DW1.
Yes, DW1.
Pillar 200. Would you agree with me that it appears from paragraph 1 of the letter of 15th October 2015 that mutation case number was 005828 June 1376 That was the question put to her on this document in cross-examination. Yes, sir. Now kindly come to the document in the judge's brief of documents part 2 at 4. And this is the document in the bunch, and tell the learned commissioner as to what is this document. This is a mutation certificate. Can you tell the learned commissioner from whom this document and in whose favor the certificate was issued? Indrajit Banerjee. Can you tell the learned commissioner as to what is the date, as to what is the date of mutation in favor of Indrajit Banerjee as it appears from this document? 20th June 2013. I am suggesting it to you that on a comparison of the document at page 2, dated 13th October 2015, and the document at page 4, dated 13 July 2013, it would be clear that the mutation was granted in favor of Indrajit Banerjee sometimes on 28 June 2013. Yes, I agree as per this document. So, my lord, this allegation that I knew of what has happened is this, my lord. It is very evident that the case number is in the date of the case in the number itself, 28 June. This is a typographical error, 1st October 2002, which they are clinging on to. Because the case started in 28 June 2013 cannot be dated 1st October 2002. And that's the reason, my lord, the mutation certificate also shows, if your lordship sees the mutation certificate once, a mutation certificate.
29 June 2013. Granted in favor of the department and favor by this department.
At the top, my lord, your lordship will find your application mutation dated 28 June 2013. And the GR case number is also there. So the GR case number is the same as indicated in reply to his RTI. The date of application is June 2030. But since they have written dated 1st October 2002, my learned friends are clinging on this to say that the mutation was done in 2002. Well, this is an error on the part of the corporation. And this error I had noticed and had brought it to the notice of the caveatrix that this is an error. And she admits that yes, the mutation had actually happened on 29 June 2030.
That is also reported mutation certificate.
Yes. But the difficulty is this, Millard, on the basis
not exhibited. It is exhibited.
Yes, Millard. It is there. This is the mutation certificate.
I do not think it's exhibited.
This mutation certificate.
No. Mr. Arif Ali, learned counsel for the defendant, objects that the document has not been proved and cannot be exhibited. That is his argument. Let him say how it is not, because the document would go in. He says that the document that goes in, it cannot be taken in and exhibited. The court has let the objection open. He has not argued why the mutation certificate cannot be looked into, because of the very simple reason is that his own witness in paragraph 2001 admits the fact that this is the mutation certificate. And he is basing his case on the mutation certificate. what should have been additionally marked over here, my lord, which your lordships, what should have been done, or probably what is being done is, my lord, it's marked for identification. This objection is recorded to be taken. His own witness has relied on a mutation certificate, so he cannot now turn around and say that this mutation certificate cannot go in. It is his own case. He is bringing his case on the basis of mutation.
Yes.
So, my lord, that takes care of 2002. So, question numbers 201 onwards.
201 to 204.
204.
201 to 204.
205 page.
205, yes, objects.
So, 2002, my lord, this argument goes out of the picture.
The document appearing page 2 and 4 of the judge's brief to be marked as an exhibit. That was the page 206, the question 206.
Yes. And you say it is 28, 29 June 2030.
Additional judges 2 and 4 of the judges part 2 judges. That document has not been tendered, my lord.
No, kindly come to the 201.
01.
Now kindly come to the document in the judge's brief part 2, page 4. The page 4 is the mutation certificate. Correct?
Yes.
Page 4 is the mutation certificate. 1, 2, 3. Page which 4? Page 4?
My lord, the 3 page, there are only 3 pages in that supplementary which I have been supplied with.
This one, you have filed?
No, they have filed.
Correspondence.
Is there a page 4?
It is your document, sir.
Yes.
Is there
Correct.
a page 4?
1, 2, 3, 4. Yes, you have stated
There is a
page 4.
In
Page
my
4 you have
document,
stated
there is only-
mutation certificate. Kindly come to the page number 3 of your judge brief document.
Maybe in my document there's only 3 pages, my lord. That's why, my lord, I was.
No, here. Can you see this? This go through.
No, lordship, whatever. Let
Okay.
my senior.
So in 201, question 201. Now kindly
page 4.
Page 4. Page 4.
This is the mutation
And page 4 is the mutation certificate. And this is the mutation. Your witnesses admitted that.
And
Correct.
204 he admits the date also.
Huh?
204 he admits the date.
As per this document.
Yes, so that is what I'm saying. That the document which you are showing, the case number in that document and the mutation certificate which you are showing is the same.
These are all surmising.
Right?
So
maybe
this certificate is exhibited.
But this certificate has been produced by them to show that. And when the witness admits, he says that it cannot be. It has not been proved. Because this part 2 is entirely their exhibit. In any event, Millard, if your lordship has any doubt as regarding the exhibit, it is a public document.
No. Then kindly come to the 206.
Yes.
No, it has to be decided by this court now because it is before the commissioner.
Oh, it was before. So yes.
It was before the commissioner. So now the court has to decide this now.
Yes.
Kindly come to the 206.
Yes.
206, I am suggesting you, the Ms. Banerjee, could you have applied for the mutation? It is a case so and so and so. I do not understand. I tender the document appearing page 2 and 4 respectively for the judge brief document part 2 to be marked as exhibit in the proceeding. Are you for the so and so objected?
Oh, that's the reason why it is not marked for identification.
Before
Because
the commissioner
could not take that call. Yes, your lordship. Your lordship. That is what I was thinking. Why is it not marked for identification? because the commissioner could not, doesn't have that jurisdiction. So now it is for the court to, my lord.
That's why it has to be now decided. Yes.
My lord, next, I like to finish it up because I keep on forgetting this. And
There is also our difficulty.
oh, my lord, I believe it's already fixed in 8th of May also.
8th. At 1 p.m.
No, 1 p.m.
I'll finish it.
3 p.m.
Yes, I'll finish.
8. Hey.
I'll finish up.
So suffering for the plaintiff, so suffering for the defendant, counsel for the plaintiff has started his argument in reply, but due to paucity of time, hearing could not be completed. It is found from the record the matter is already fixed on 8th May. 8th May at 3 p.m. Let the matter appear on 8th May at 3 p.m.
For my lord, right there. Maybe my lord, actually outside I apologize, my lord. May I be permitted to mention a matter? My lord, I
To
apologize.
err is human.
May I be permitted to mention a matter, my lord? For inclusion in the list, your lordship will recall that matter where Mohesh Thakur matter, my lord, where the GA2, my lord, the order 7 rule 11 was dismissed, my lord.
Which one?
Come to the point. Come to the point.
For inclusion, your lordship, in the list, your lordship.
How did commercial matter?
Commercial matter, my lord.
Ah.
The my lord, we have filed extension for writ of summons, my lord. There are some discrepancies which requires your lordship's intervention. My lord. So may
Who is for the other side?
My lord, I am mentioning upon notice, my lord. My lord, I'll further issue another notice if your lordship pleases.
Monday रंग दो उसको. To be mentioned. कोई interim order तो नहीं है ना? हाँ Tuesday.
Point बोल रहे हैं. जज की